Good morning. This is the New York City Board of Standards and Appeals Public Review Session for December 15, 2020, 10 a.m. session. The first item up is Appeals Calendar, New Cases, item number 28, 2019-176A, 17 Eastern Parkway, Brooklyn.
Okay, so this is a new case. Just a second. And we do have proof of service of initial application to DOB and city planning. This is an interpretive appeal. With respect to the statement of facts that was submitted on January 17th, 2019, it isn't clear from the introduction whether we are expected to read the earlier statement of facts as well as the one that was submitted on June 19th, 2019, that related to what is described as the, quote, original denial of May 21st, 2019 versus the, quote, revised denial of December 19th, 2019. The later statement of facts rambles, unfortunately, and appears not to have picked up the arguments made in the ZRD 1. For what I think is most relevant data, what most of the relevant data, I think, you have to read the appellant's argument in the ZRD. So that's in case the commissioners might not have done that because the arguments are kind of all over the place. The ZRD has data that doesn't appear in the statement of facts. The original denial and the first statement of facts are in the void folder, and I think it needs to be taken out because it's referred it's referred to in the second statement of facts. And though I have to say, after trying to struggle through the second statement of facts, I couldn't struggle through the first one because I didn't know what was redundant and what wasn't, and I didn't know why I was having to read two sets of statement of facts. So we are being asked to opine on whether the use of a house of worship as a venue for music and spoken word performances is accessory to the principal use of the building as a house of worship. According to the statement of facts, 2 halls in the house of worship are being used as a venue for performances managed by an outside entity called Murmur and open to the general public. As far as we are advised, this entity is not a subsidiary or affiliated with the house of worship. Murmur's Facebook page describes its operations as a venue at Grand Army Plaza that includes a, quote, 700-person capacity theater with, quote, towering stained glass windows and a 20-foot high arc, unquote, as well as 288-person capacity, quote, ballroom, unquote, with a, quote, busted chandelier and a 1920s decorative ceiling, unquote. There is no mention of the fact that the venue is a house of worship of any type. So it seems clear that the Union Temple, the actual subject of the application of the appeal, is renting the space at night to persons unrelated to Union Temple itself. So my first question is doing that unusual? I've been to and am aware of other houses of worship that hold music and dance performances in their sanctuaries. Is there a difference here? Has appellant researched the situations of the houses of worship that are listed in the ZRD, where there's a whole list of many that are claimed to have performance activities? Appellant can't just hand the board links to the institution's website and expect the board to construct the argument on appellant's behalf. And there, I don't know about these that are listed in the ZRD. I know of others, but I don't know at all what the situation is. And I want to say that, for example, I've attended many performances at the Cathedral of St. John the Divine on the Upper West Side. St. John is a very wealthy church, and they have a very elaborate music program. However, if you look on their website, they have an entire music department. They have one of the most important choirs in the country, maybe the world even. And their musical component relies very much on bringing outside performers that work with the musical entity that is part of the church. And so the most recent concert that I went to back in the days when a person could go to a concert, the performer came from Europe, and the performance was about a World War I soldier who composed ecclesiastical music, so ecclesiastical Christian music, and it was performed by this European group, and the piece was introduced by the choir master or the director of the church's musical program. So for me, St. John the Divine has always had a connection between the church and the musical program. I've never seen sort of random, heard about random performances that aren't connected somehow to the church. So that one's easy for me to say is accessory to the church's activity, to that institution's activity. I don't know about all of those other ones that are listed, and the appellant can't just throw them at us and say it's the same. We don't know. How is it set up? So, and I don't have to think that the type of performances, whether heavy metal or quiet folk, as appellant appears to be arguing, changes the basic question, because heavy metal can be ecclesiastical in nature. A lot of it actually is. And quiet folk can be completely unrelated to the subject of spirituality or whatever it is that the congregation pursues. At the same time, we also confront often enough other religious buildings, schools mainly, that attempt to use their spaces as banquet and commercial catering facilities, which this board has found not to be incidental to the principal use when the venues appear to be open to the general public as opposed to the congregants only. DOB cites the 2006 BSA decision 60-06A at 1824 53rd Street, that's known, we know as Visnitz, in an R5, which involved a religious school for 625 students with a very small 1,900 square foot sanctuary space and an 18,000 square foot cafeteria and auditorium in the cellar that was being used as a, quote, catering establishment, which is really probably a misnomer, probably more of a banquet hall. DOB should have included, and I asked them to do so, though we kind of did our own research, but they should have included the history of this case following the BSA's decision as it was litigated in state and federal court in 2009 and in federal court in 2011, the latter of which, federal court, considered federal claims under RLUIPA, the religious, whatever it stands for. Council, can one of you jump in to just tell us what RLUIPA stands for? Religious
Land Use and Institutionalized Persons Act.
Thank you very much. Although the court dismissed the claims, the federal court, because all the issues had already been litigated in the state court. So the federal court didn't go didn't come to a determination because it was issue precluded. Appellant's argument that the venue is used infrequently by Murmur seems to merely reflect Murmur's relatively recent entry into the event planning scene, as the months of October and November 2018, for example, show actually 5 events in 1 week and 13 events in a month, which presumably could have been more had there been bookings and had there not been Thanksgiving holiday in between and so on. This all has to do with, I know people who are event booking agents. And when they first enter the scene, nobody knows who they are. So at the beginning, it's hard to find acts that are willing to kind of have you locate them in your venue or in the venue you found for them or whatever. But as you become more and more known, people will say, oh, wow, a performer will say, oh my God, I got a call from Murmur. This is so exciting. They're going to book me in their venue. So eventually it becomes desirable to be booked there. And it seems like in the months of October and November, Murmur was becoming known in the music scene and they were getting more bookings. That's just kind of logic. I don't know it for a fact. Appellant relies heavily on the equal protection provision of the Religious Land Use and Institutionalized Persons Act. I just realized I wrote that down later. That states, no government shall impose or implement a land use regulation in a manner that treats a religious assembly or institution on less than equal terms with a non-religious assembly or institution. DOB must address this claim of unequal treatment in light of their tacit acceptance of similar uses in community facility buildings in the immediate area, taking the decisions in the 1824 53rd Street case and the 2008 Church of Christ Science case into consideration as well. Church of Christ Scientist was the case that determined that you could not treat other institutions differently. And if that church received basically a shutdown order, that the neighboring community facility buildings had to receive the same, or not community facility, one of them was a residential building, had to receive the same kind of treatment, otherwise it was not equal treatment under our LUPA. So I don't think DOB's papers went far enough on that claim about unequal protection. And they claim that the Brooklyn Public Library and the Brooklyn Museum both hold similar events only pursuant to the temporary public assembly permits without support for that statement. And I have to say, though I haven't been to performances at the Brooklyn Public Library, I have been to the museum. I have trouble believing that every single event that they hold gets a TPA. Instead, there must be an argument that can be made that there's a difference between those two institutions and their connection to culture, which I would venture is the issue, that the library and the museum both are cultural institutions and both are educational, and that music and performing arts are as much a part of our culture and our education as science, as any of the other subjects. They're part of the STEAM programs that we learn about so much in our cases where we hear schools, variances for schools. So I'd like to have DOB clarify what's the distinction between those other community facilities and this one that makes similar activities acceptable and this one not. So I think there are more questions so far than there are answers on this. And I'd like both appellant and DOB to do more homework. So Vice Chair Shanda.
Okay. It's interesting you mentioned St. John the Divine. I actually came to know of it because it used to hold Indian concerts there. Mm-hmm. That's how I became familiar with this. So, and I don't think it had anything to do with the program, the St. John Divine's, its own program, other than the fact it believed in world music and it promoted it. So just as an FYI kind of thing.
What? Sorry, I missed that last.
World music. It was championing world music without it collaborating directly or indirectly. So in support of that. And I've gone to many concerts that are non-religious related in religious facilities that have no connection with the particular program that is being held. So that was in my mind as I was reviewing this case, and I was trying to figure out how does one parse out that difference. And then DOB mentioned the case 1824, which had to do with banquet. And I do know that when we review schools, we are very careful that the cafeteria spaces are being used for cafeteria primarily and not designed for banquet halls primarily, which is very different, which is much more discernible. So I have to say I wasn't convinced with the DOB's arguments. I did not have a chance to look through every paper, every document carefully. So my apologies on that. But based on my preliminary review of the documents provided, I had similar questions, Madam Chair, that you have raised about DOB statements and need to go into more specificity with regards to the 1824 case. And also, now that you're mentioning the LUPA, would definitely like them to clarify the LUPA issue.
Commissioner Ali Brown.
So having been one of the commissioners who is still here, who was around during the Vishnitz case, because that was probably one of the first cases I actually voted on, I actually find that in this situation, Department of Buildings is actually applying lessons learned from the Vishnitz case in an attempt to actually standardize the way in which they're looking at these situations. And while I do agree with you, Chair, that they do have to provide some more backup information other than their reasoning, I think that they're on the right track. I think, you know, as in the BSA resolution, the things to look at in terms of determining that second prong of incidental and customarily found, intensity of use, frequency of events, hours of operation, availability of parking, management of food operations, relationship between the size of the synagogue membership and the size of events. You can apply those things towards this case and the proposed concert hall usage. So I feel personally that they are coming close to proving their case that the Murmur Theater is not clearly incidental to the use of the synagogue, simply because it is not limited in its events, limited only to synagogue membership and their close family and friends. The events are not religious in nature, and they are not performed by people who are spiritual authorities even. The advertisements are aimed at the larger community. In fact, you really don't even know that you're going to a synagogue, because I actually was going to go to one of the concerts when I was living in Brooklyn that was at the Murmur Theater. It was the Tegan and Sierra concert. And I was like, where is this? Because I'm literally right across Grand Army Plaza. Where could this possibly be? Because I have never seen anything that said the Murmur Theater. And then when I pulled it up and I was like, oh, it's in that synagogue. Right. So it's like, it's clear that there's no connection to the synagogue. And so I'm not very convinced by the appellant's arguments that while these events may not be spiritual in nature, what they're doing is they're fostering a connection to the synagogue amongst Jewish people who may not know that there's a synagogue there that they could belong to, because there's no way of ever knowing that you're going to a synagogue until you literally show up in front of the door and go, oh, this is the Eastern Synagogue. So what I do think would be helpful would be if DOB backed up their analysis in terms of the number of events versus the number of synagogue-related religious events. I also agree with you about the unequal treatment argument that they put forth. While it is reasonable that they're giving to this synagogue the same opportunity, so to speak, as Brooklyn Library, as well as the Brooklyn Museum in terms of getting the TPA that would be valid for 90 days at a time, they would need to prove that they're doing the same thing with Brooklyn Public Library and Brooklyn Museum. And that to me is pretty easy to do. You just have to show when the TPAs were issued and all of the events that follow the TPA's validity to show that in reality, that's how they're treating the other cultural institutions that are in the general neighborhood. But I do overall think it is sound city policy to not allow these kinds of events, because this is a residential neighborhood. And those intensive commercial events really do affect the people who are living in the neighborhood who have no idea, because it's not transparent. It's not like you're living in a commercial district, so you know that, okay, there could be intensive commercial uses when you choose to live there. This is a religious use that's, as of right, in a residential neighborhood, now having commercial, or commercial occurrences under its roof. And that really is disturbing the people who have a right to live in a residential district that they chose to live in that is almost entirely residential in nature in terms of the things that go on there.
Thank you. I just want to jump in one last thing about these TPAs. I've been involved with an organization that holds its fundraisers in different kinds of very odd venues. Oftentimes they don't have certificates of occupancy even. And the Department of Buildings requires a TPA in part because they don't have certificates of occupancy, but when they do, they only require it because we're exceeding the 75-person maximum. So I'm not sure if the venue doesn't hold more than 75 people, whether you would need a TPA in a building that already has a CO. So I actually don't know the answer to that. I think DOB should respond. Commissioner Shaitan.
Thank you, Chair. I'm going to start by taking, after going through the submissions from both sides, especially the very brief submission from DOB, I'm not taking a position so far. I'm like leaning to listen to both arguments. And I do have some questions. Before that, I would like to say that the impact on the neighborhood shouldn't be a governing factor for classifying such use, the subject use, whether it's accessory or not, to the principal use, which is a house of worship. I believe we should determine that based on the definition clause in ZR 1012, which give us a three-pronged test, and we should go through these three clauses and see which one is satisfied and which one is not. And if there is one that's not satisfied, it's a done deal. So looking at that,
I just want to interrupt for 1 second. I don't know if you read what we're calling the Visnitz case. What Commissioner Ollie Brown was referring to was a case that was at the BSA related to the catering establishments that was upheld in the courts, and it was DOB and then the BSA adopting a multi-pronged test to determine whether a banquet facility was an accessory use, right? So whether or not you apply it in this case, DOB is applying the test that was accepted and sort of used by BSA in that business case. And then the court upheld that, though the court did express, I think in that case, I'm not sure, dissatisfaction with its kind of unclear, with DOB's unclear behavior. And I think maybe DOB now is trying to be more clear by using that multi-pronged test in Visnitz to apply generally. So, it's not to say that this board couldn't sidestep that or change its approach. There's been time, but you should be aware that the courts upheld that analytical method. If I've got that right, please counsel jump in if I'm remembering the cases wrong. Okay, please.
sure, thank you.
That's the case. And so the board went through factors in determining accessory use when applying the statutory definition that Commissioner Sheta just mentioned in calendar number 60-06A.
Okay, but also the DOB's tests in Visnitz?
Yes, I believe so.
Okay, so it was those kind of very multi-pronged. Okay, I'm sorry, thank you.
For instance, the resolution states,
Yeah, go ahead.
The resolution states, as discussed at the first hearing, the board considered the following items to be among the relevant considerations and asked for information as to each of them: whether the catering establishment has separate entrances and lobbies from the school and synagogue, the hours of operation, whether the catering establishment has separate garbage pickup from the other uses, the frequency of outdoor activities related to catered events, the relationship of the events to synagogue members or school students, staff, family members, and traffic and parking impacts. And these were factors that the board was looking at in analyzing the accessory use under the statutory definition in 1210.
Thank you. Appreciate it. Okay, I'm sorry, Commissioner Shaita, go ahead.
That's okay. That's okay. I believe I did read through that case in papers that were submitted, and I believe that being used as a way to determine how much incidental the catering use in this case to the principal use. This is the way I looked at it. But in this case, I believe it's more clear. My understanding is that what the applicant is saying is because this, what is so-called accessory use, what he's claiming is an accessory use to the house of worship, is used for a small portion of time as it compared to like the total time within a day or a year or a week or whatever. Because that portion of time is small, it is incidental. This is one of the items that he's using in his argument. The second point I got, he's saying that because it's beneficial to the house of worship, then it might be looked at as it passes the 3 tests in the zoning resolution. My point is this. Second point B, calls for 2 conditions. Number 1, it calls for incidental, should be incidental. And number 2, it should be customarily found. And I'm not sure, what I was anticipating from the applicant is to give us some examples for other house of worships throughout the city that has similar uses. When I say similar uses here, I'm not just talking about performing art and music. I'm talking about a contractual relation between whoever is running this accessory use and the house of worship. If he can provide us with other places in the city that utilize the same contractual relationship with the same amount of time throughout a month or a year or whatever, that would be helpful for us. Because so far, I'm not sure whether this could be considered incidental nor customarily found. Customarily means that it's very common. It like in every 10 house of worships you look, probably you're gonna find 7 of them has the same thing. I'm not sure if he can submit something like that, that would be helpful to me. Regarding the impacts, I would like to DOB to clarify, at least to me, maybe it's clear to other commissioners, whether they consider the impact on the neighborhood, including parking, noise, and such other negative impacts, a governing factor in determining whether this is an accessory use or not. That wasn't so clear in DOB submission. It was one of probably the most brief submissions that I looked at from DOB, and it was really good submission. For the time being, these are the two points that yeah, one more thing, the for-profit, the applicant is kind of getting nervous when DOB calls this a for-profit use. I'm not sure if the applicant read through page 25 of his statement of facts, the updated one. And on that page, it says the net proceeds, of course, are what is left after the performing arts have been paid. Murmur technical and operation staff are paid, and all other costs and expenses are paid. So what is remaining after that is getting split between the house of worship and the operator, murmur. So I look at this like this is the textbook definition of the word profit. It's expenses minus cost. Whatever you spend, I'm sorry, expenses slash cost minus income. And if this is the way that the whatever is remaining is distributed, I believe this is, like I said again, this is the textbook definition of the word profit. And of course, this is clear cut for profit use. And I can see the conflict between a nonprofit use like a house of worship and a purely for profit use like the use that's currently claimed as accessory. So we need clarification on that. What is the position of the applicant? Whether this is a for-profit or a nonprofit? Do they consider it a nonprofit because it's just related to a house of worship? That's all for now. Thank you.
Okay, thank you. And Commissioner Shabeta.
Thank you, Chair. So much of what I was going to say has been said, but I think it bears repeating that there's a three-prong test in 1210 that's been upheld by Botanical Gardens case, and the Court of Appeals upheld in Botanical Gardens case, and we have to go look at what the tests that we've used and those reasoning behind 6006A. That being said, I do appreciate your Chair's statement with regard to equal protection. I think that while I do believe that most of this has been much of my the reasoning in the second page of DOB's statement, I think is sound. I do think that they should address the equal protection question a bit better. As it stands right now, I am strongly leaning towards DOB's position. I think it's sound and supported by law. But I'm open to hearing more about the debate later today.
Great. Thank you. Thank you, everyone. Vice Chair Sean.
I have a question. So if the organization is a nonprofit organization that is renting the space for its own programming purposes, is that then different from a for-profit organization renting the space for its programming purposes, regardless of whether it's Murmur or someone else or some other organization or whatever kind of program is it?
I'm sorry, I didn't hear that. Can you repeat that, Chair, Vice Chair?
So my question is, this is just a question that came to my mind as Commissioner Shetta was talking about the clear, it's clear in terms of the way the setup is that it's a for-profit. So my question is, if, regardless of whether it's Murmur or some other organization, if it's another nonprofit organization that is renting a space from a place of worship for its own programming purposes, does that make any difference versus if it's a for-profit organization that is renting the space for its programming purposes? Is it viewed differently by DOB? Is it viewed differently by any of the rules? It's a question I'm asking. I don't have the answer. I'm trying to understand it.
Right.
I just forgot to mention one thing I've noticed on Murmur's website is that they do rent out the space to anyone willing to rent to purchase it. If you go to their website, you'll see rentals, host your next event here, and we accommodate photo and video shoots, corporate dinners, fundraisers, speaking events, cocktail parties, dance parties, weddings, and more. I just want to mention that.
Okay. Okay. Thank you.
So that also brings up the common phenomenon of religious buildings that rent out to congregants. I don't know if they rent out beyond that. We certainly see that with the schools that we have tried to prevent from doing that, where they rent out generally. And so would it make any difference whether that aspect of it is handled directly by the religious institution or by a booking agent, right? Does it make a difference if it's generally available to the general public as rental for events? That's tricky. And you know, had the institution been really successful with this and had more bookings, then it gets into a whole tax criteria that can subvert the not-for-profit institution into a for-profit institution because they make too much money. Yeah, Commissioner Brown. Did you want to add something?
Yeah, it's an interesting discussion to have, but to me, the very nature of for-profit is to maximize profits, and maximize profits leads to intensity of use, and intensity of use leads to disturbing the community in this case. And so that's why I think the fact that it's for profit is an issue in this situation. And so, and I see also like your statement about it leading to tax implications that could blow back against the not-for-profit status of the entity that actually owns the property. And we see that time and time again at Department of Finance, where I was, where a religious institution would have not-for-profit status and be non-taxable, and then would lease their space out to a for-profit operator, and then all of a sudden their exemption's removed and now they're taxable. So there are a lot of implications that go far beyond just the zoning land use issue.
Right, right. Thank you. Interesting. Okay. That's great. Okay, great. Thank you. Anybody else? Did we leave anything out? Council, feel free to jump in if we left out prevailing legal considerations that we should take under, that we should be paying attention to.
I just wanted to point out that 6006A does also talk about bingo nights, and there was a statement from DOB in that case where such activities would not occur every night for weeks at a time. It would allow bingo or Las Vegas nights 1 to 2 nights per week, but this speaks to the relevant factor of the frequency of activities.
Okay, great. Great, thank you very much.
Okay, next item is zoning calendar, continued hearings. Item number 29, 2017-34BZ, 311 Adams Avenue, Staten Island.
Sorry, scrolling. Give me a second, getting there. Okay. At long last, the project was actually revised to put the parking under the house and to lower the height of the building somewhat. The site plan shows 3-foot high planting along the Adams Avenue property line. Even if this doesn't comply with 23-451 requirements, that planting should be a condition to approval to lessen the impact of the height of the house. I understand the site's so skinny, there's kind of nowhere to put it, but there is room there and it should be placed. I'm not certain, and we have further information from DOT, I'm not certain that the curb cut at 17 foot wide complies with section 25-622 and 25-632 for lower density growth management areas. I read that provision over and over again, and I just wasn't sure whether this would qualify. Both provisions limit curb cut widths where the, quote, street frontage or, quote, frontage along a street is less than 33 feet. In those cases, it's limited to 10 feet. And section 25-632 limits curb cut locations to at least 13 feet from neighboring curb cuts. So we weren't provided with information on what the neighboring curb cut is. Although that was discussed at the last hearing, I don't believe there's a neighboring curb cut, but you actually have to show it to show compliance with zoning. And it depends on DOB's reading. That's the part that I'm having the most trouble with, unless we have a BSA decision that's already decided what this means. It's the reading on street frontage, quote, and frontage along a street, unquote, on a corner lot? Do they assemble those two frontages that equal 33? Because the curb cut is on a tiny frontage, like 17 feet wide, 18 feet wide, right? So it wouldn't qualify if each frontage is viewed separately in this provision. It would if you can combine those two frontages on a corner lot. So the applicant really needs to verify that. Otherwise, they're going to need a waiver on that one, which they asked for initially and then withdrew. So we could also just say, don't withdraw it. And if you don't need it, then we and don't use it. We also reached out and Angela, if I did read your email, we reached out to DOT because we weren't sure about, independent of zoning, whether DOT would accept a curb cut that close to the corner. DOT said it would accept the curb cut, but it advised that there's some kind of overhead line. What is it, Jella? An overhead what?
It looks like
Some
there's
kind
a
of
utility pole.
Utility pole with an overhead line or something like that.
With
that would
guy wire
obstruct-
spans.
That's what it was. I have to find your email. That would obstruct the access to the garage, and they cautioned that that might be too costly to relocate. So
Yeah, the
applicant-
utility to, sorry, to, just to help you. Relocating the utility would be costly to, because it would obstruct the curb cut. So they suggested as an alternative a curb cut along Adams Avenue.
which is what we had talked about, 2 hearings ago. Instead of having it come directly into the house the way it's shown, we talked about it going underneath the house on the other side. So I'm not sure, but really the architect needs to do a site visit before it makes offers. Maybe it wouldn't be so expensive, don't know, because DOT doesn't manage that utility, I guess, right? No. So the other part of it is, in terms of zoning, is that the rule is that the curb cut has to be centered on the driveway. And everyone knows that I'm not a skilled driver in curb cuts, so please jump in if I'm making a recommendation that won't work. But I asked why the curb cut, and that might help in terms of this utility problem, why the curb cut can't be 10 feet wide and centered on the driveway instead of 17 foot wide. And then that gives also the opportunity for planting on either side of the curb cut, because they're just paving the entire frontage there. So it seems to me that you can go up the curb and then splay out, and that would splay out to the garage in some fashion. And by moving the curb cut over, maybe you avoid let's say reducing the width of the curb cut, you avoid the issue with this utility problem. So they should look at that. There is exterior insulation finish system noted, which is specifically not permitted here. IFAS notation is on the elevation. Take it off. The cover letter says the new material is fiber cement lap siding, as is actually shown on the other side elevations, and described in drawing BSA 12 as hardy plank or equivalent. And hardy plank is a good material that holds up under all kinds of extreme conditions. As stated at the prior hearing, IFAS is not a permitted material at the BSA. And the hardy plank also, or that's a brand name, but that cementitious material comes in all kinds of finishes. So if you're going for like a stone look, which is what the facade seems to be going for, you can get that from that material. The height above grade is 29 foot 7 inches plus 5 feet, or 34 foot 7 inches to the top of the ridge, which complies with the maximum height of 35 feet above grade. Similarly, perimeter wall height complies at 21 feet above freeboard and 26 feet above grade. I was checking that because I'm not convinced that you can measure above freeboard when you are not lifting the building according to the zoning regulations. You know, in other words, you don't comply with all of the mitigation requirements. So they need to also show the depth of the balcony in the plan and on the section. We asked for this at the last hearing. We see the balcony, but it's never been dimensioned anywhere. They also need to show the borough on the title block. I always find that funny. The title block doesn't really tell you where this house is. And they also need to show the flood zone on the zoning drawings. It's AE12. So show that on the drawings. This case has been at the agency for nearly 4 years. Prior to initial hearing, we received a title company report stating that the site has been held in separate ownership between 1961 and 2010. We need an update on this report because we need to know that it's been continued to be held in separate ownerships between 2010 and 2020. Staten Island, this is for the benefit of kind of everybody. I didn't know this had happened. Staten Island now has a new program to research title, which is far from the sophistication of ACRIS, which Staten Island for some reason doesn't participate in, but at least it's accessible and a lot easier to use and accessible, and the images show up when you click the image button. And so based on my research there, I don't think there's been a title transfer that would affect our findings, but we need this document updated. Normally that would be the title company that does that. The survey and actual site conditions don't match with respect to the condition of the existing sidewalk. This project must provide a sidewalk and must file a builder's pavement plan. But Adams and Haven are mapped streets since the issue is the widening line. So we don't have to worry about any kind of GCL waiver. No, they're not building the widening line. They're holding back the widening line. So, but the survey and actual site conditions don't match. So you need to correct one or the other. You actually need to correct the survey. I don't understand why the survey doesn't look like the actual site conditions. Also, I'm sorry, this goes on a bit because I was really digging in. Also, I need confirmation that the survey, hence the elevations used in the building design, are in NAVD 88. The 2010 survey, which is before Sandy, indicates the elevations are in borough datum. So that's not NAVD 88. And then there's a 2016 notation about NAVD 88, but I'm not sure which is which from the drawings on the survey. And if I'm right, and according to conversion tables, the survey is stating that the grade level is actually more like 11 feet NAVD 88 and not 9 feet as shown on the plans. So the surveyor has to clarify this on the survey. So if instead its grade level is 11 feet, would mean that the building is being lifted higher than required. However, I want to say that without the lift as proposed, whether or not it's higher than required, you wouldn't then get a usable underside on that grade level. You wouldn't get a usable kind of walking around storage and garage. So I'm not saying you can't lift it, but it's misrepresenting that it's being lifted so high. So I believe that the drawings are not in NAVD 88. So I have to say this is about cleaning up the plans and making them as accurate as possible. And that's why luckily the height complies, even if the height elevation for the FRCE, the freeboard, is lower. So the building is compliant off grade as to height. So that's kind of the reason for my investigation. And applicant, please ask questions if you didn't understand what I just said. And those are my comments. Vice Chair Shanda.
My only comment is with regards to the curb cut width, because as per zoning resolution section 25-631, which applies to low density growth management area, it says for zoning lots with less than 50 feet of frontage along a street, only one curb cut having a maximum width, including splays of 10 feet shall be permitted, unless they're seeking a waiver of that, which I don't believe they are.
Right, they were, and then they thought they didn't need it anymore. I don't know how they concluded they didn't need it anymore.
Right. Other than that, I'm fine with the revisions made.
Okay, thanks. Commissioner Otley Brown?
I'm also fine with the revisions. They just need to reconcile the total building height. In one place, it says 29 feet, 7 inches. In the other place, it says 30 feet, 3 inches.
And that's on one drawing or in different drawings?
Different drawings on the proposed plans. And also it's cited in the, I guess, cover letter / narrative saying that they lowered the height to 29 feet, 7 inches. But if you look at one of the elevation plans, it looks like it's 30 feet, 3 inches.
Okay. And, you know, I think some of that confusion is where are you measuring it off of? If they measure it off of design flood elevation, that's a number. If they measure it off grade, that's a number, you know, all of that stuff. Okay, thanks. Commissioner Shaitan?
Thank you, Chair. I have no further comments, and I want to thank them for adding this note about that drop beam design. I want to alert them that this beam is going to be too heavy. It's almost carrying the entire, like 50% of the building actually is carried by this beam. And I do have a suggestion for them. If they can just turn the framing for the first floor like 90 degrees. So make it span between the two walls, and instead of spanning between the drop beam and the other wall at the staircase. I believe that's what they can only do to mitigate the load in this beam, which I believe, like I said, it's gonna be too heavy. And I'm afraid not just they're gonna miss the beam, but the footing as well. This beam is gonna need 2 columns at the edges, and these 2 columns should be provided with 2 sound footings. Otherwise, this building could easily settle. Thank you.
Okay. Okay. Thank you. Commissioner Shabeta?
Nothing further from me on this, Chair.
All right, next.
Item number 30, 2019-24 BZ, 2721 Nostrand Avenue, Brooklyn, and I forwarded a FDNY email letter.
Just
Do you want
now?
to,
Or I didn't-
before, while you were talking, I'm sorry.
oh, I can't see it. So,
All right, so you want me to read it?
yeah, please.
The fire department has reviewed, Bureau of Fire Prevention has reviewed the revised plans dated November 19th, 2020 for the above noted application to be heard today. Plan number A 102.00 shows one access point indicated by an arrow for fire department roof access. Such access is not in compliance with section Fire Code 504.4 in that access has to be provided for every 12 feet along the entire length of the building. Elevation plans do not show any openings along the building wall. In addition, how would the stackers located on the roof be protected? The use of stackers on the roof is defined as high piled storage, and protection for these stackers are necessary. The off gases of vehicle fires would create hazardous conditions for responding members and the general public. To date, no filings have been made to the Bureau of Fire Prevention's Tech Management for plan review. Therefore, the fire department's letters of objection have not been complied with. We respectfully request that the board direct the applicant to revise their applications and plans to comply with the fire department's objections to this application. Respectfully submitted, John F. Daly, Deputy Chief Inspector.
Thank you. So certainly I would want to hear more about the high pile storage and off gases when we open the hearing to public testimony. Since this is a very controversial application, we requested at the August hearing that the next hearing be noticed, and we have proof of notice of hearing to officials and neighbors that was sent out on December 1st. We have several letters of strong opposition to the project from the immediate neighbors to the rear, who describe the uncooperative business that is the subject of this application and their unwillingness to, protect these neighbors from the detrimental aspects of the business and the construction of the subject parking garage. And I'm just warning everybody, my comments are lengthy. It's a very difficult application, I think. Although we had submissions in purported response to BSA comments and directions, the project basically has not changed, and the submissions are intended to argue further for an unchanged project. And rather than go through systematically each of the commissioner's comments, as is the norm at this agency, and with this applicant's representative, so not being handled typically by this representative, comments were selected for response and others completely ignored. In particular, board comments having to do with noise and parking, traffic and pedestrian circulation were ignored, and responses directed only to DOT's and DEP's comments. This is unacceptable. This board makes the final determination, and its questions are independent of the questions from other agencies. One of my comments had to do with the height of the structure in the rear yard, which is not permitted to be greater than 23 feet above average curb height. I observed, based on the October 21st, 2019 sectional drawing, that the building at 49.4 feet to the roof was actually higher at 25.36 feet above average curb elevation, which is an elevation, sorry, I'm reading. Yeah, so should not have been permitted in the first place, and therefore no further obstruction within the 30-foot rear yard could be accepted here. The ZD1 drawing on BIS shows the curb elevation at 23.04, and so that's consistent with the sectional drawing that was provided to us in October, and the height of the building provided in that section was 25 feet, 25.36 above average curb. The new submission provides an average curb calculation using the entire 240 feet frontage of the building, which parenthetically, I'm not sure is the correct method since this is a horizontal extension and the existing building isn't part of it. So I'm not really sure how DOB looks at average curb height. But and so in that 240 foot frontage, there are 10 top of curb elevations, and they took those to arrive at the average curb elevation of 23.76. So that's pretty close to 2304, but comes up with a entirely new roof elevation of only 45.4 instead of 48.4, which was shown on the 2019 sectional drawing. That's a very big difference. So they claim this is an as-built survey, but they put the survey on the architect's drawings. So I would like a survey that is not on someone else's title block, and where it comes directly from the surveyor, and have the surveyor actually go back and check the finished roof elevations at 5 points along the entire rear wall line and to the top of the parapet. So sorry, I'm skeptical. Once you submit incorrect data and then all of a sudden fix it, I'm skeptical. So potentially the building is 2 feet too high. Then the noise report at page 3. So again, inconsistent, uncoordinated submission. The noise report at page 3 states that the roof height across the structure will be increased to 30 feet. And that the study provided by Urban Cartographics that doesn't say that is in error. in describing the roof height at 23 feet. So I read that, and to myself, I said, what? It's being raised to 30 feet? What is going on? What's happening? Also, the same section in the EAS, Purpose and Need, to which the DEP refers in its letter, shows only 63 cars on the roof instead of the 73 we are shown. Have DOT and DEP been getting consistent data? I don't know the answer to that. Are they reviewing the same number of cars, the same impacts, the same heights? The consultants need to coordinate across all of the materials submitted to all agencies, and it shouldn't be this board that finds the inconsistencies. That's completely unacceptable. It's poor management of your project. I could go on and on about how terrible that is. Okay. So, and please provide also the correct hours of operation for the entire facility that relies on the 2 curb cuts accessing this building. The documents give all different hours of operation. And the website disagrees with the statement in both the noise report and the parking study about the hours of operation. So those agencies that are reviewing it, DEP and DOT, are relying on those hours to make their determinations. And if they're misled, then they're using different data, incorrect data, to do their analyses. As requested, applicant's consultant went back over the examples of rooftop parking that were provided previously to examine how such sites came to be, because I asked, are those legal sites? And as suspected, nearly all of the sites were constructed prior to 1961 or without any known explanation for being permitted to have rooftop parking. Of the 3 that were subject to BSA action, 696 East Fordham Road received a variance in 1997 for a government building to permit 38 rooftop spaces for employee parking. So that's 38 spaces. So that's less than half of what is proposed here. Sorry, that's half of what is proposed here. The other 2 obtained 7349 special permits in the mid-1960s when the BSA of that period made no findings, described no parking count limits, and imposed no conditions. So you can't use these for comparison. No doubt the installation of any protection at all that's described in that report was in response to neighbor complaints, but the deed was already done. Those parking installations were already there, and there was no agency in charge of ensuring absence of impact on neighbors. There's a typo in that same report referring to the report of the existing rooftop parking garages. There's a typo in that report that refers to section 35-36 for screening requirements in C districts with sites that are located adjacent to residential district boundaries. It's not 35-36, it should be 36-56. To note, first of all, that this requirement applies to as of right uses, and rooftop parking above a basement is in fact permitted as of right, and that this board has the discretion under 7303 to impose greater restrictions to mitigate the negative impacts of proposed uses in discretionary actions. There is a section in that study showing a compact car headlights projection. It appears to show headlights casting light below the surface of the earth and not higher ever than 42 inches above grade, by way of arguing that there won't be headlight disturbance to the neighbors at the rear. First of all, I'd like to know about the SUVs that customers primarily drive with headlights that may be higher than 38 inches above grade. Not sure, not a headlight specialist. And all of the cars in the world, really, with their headlights no longer tuned to factory standards, if those are in fact the standard, and the fact that a headlight is designed to illuminate roadway signage and all of that, that is far higher than 42 inches above grade. So I don't really understand that headlight section, because I'm not understanding why, if it's only lighting to 42 inches, how you can read the next exit if you're driving on the Merritt Parkway, for example, where the signs are not illuminated. Um, and the other thing is this diagram about projector or reflector headlights, since there's a difference in light spread and maybe there's even another kind. And there was no source provided for this information. So I don't really know what this is that we're getting and where the expert source is. On the rooftop landscaping question, no changes were made to the proposal other than the addition of a wooden fence facing the exterior, to which will be attached at the inside face the same acoustical fabric we saw the last time. We were provided with pretty photos of some rooftop landscaping that even had a few trees in other locations by way of trying to prove to us that rooftop landscaping actually lives. But in the Not Born Yesterday department, I did a bit of my own research on these sites and see that in the cases where there are some few trees, the roof is built up significantly to support deeper and broader tree beds. At the Boston Health Center site, for example, the trees even sit on a hill. And at the Albany site, the trees are in deep planter boxes. So otherwise, all of the growth that's shown on those projects are low-lying ground cover and low shrubs. So unless there's an intention to build a hill here to support the tree base, where you don't have room with your only, whatever that is, 10 foot of depth, I don't see the argument for the trees. I might even believe the idea for the roof if the landscaping program were for an extensive green roof as described in the architect's website for the Boston project. We have also not been given the details that were used for these sites, the sectional details that go through the planting and show what the technical methods are to make those planters work. They probably have heating systems and watering systems and all of these things. These are expensively done installations. So we haven't given details for that. And those are seriously landscape roofscapes, clearly with full-time landscapers engaged to replace dying vegetation on very accessible, visible, and publicly important locations such as medical centers, university. And so I'd like to know, how is that comparable here? This is not at all one of those types of facilities. On the parking issue, I don't think we were provided with an explanation for why there can't be 84 parking spots in the as-of-right cellar as shown on the proposed, instead of the 42 shown in the as-of-right. We asked for that the last time. And 82 on the first floor, which would give a total of 166 as-of-right spots. That's an improvement by 52 spaces, which is only 20 shy of what is proposed on the roof. And I'd like to know, from where is the 123 space as of right limit coming from that is mentioned in the EAS and the traffic tech memo? 51 are described in the cellar and 72 on the first floor. So that's another example of the drawings that we see versus the information that the reviewing environmental agencies are getting, not matching. We're told it's 114 and they're being told it's 123. And why couldn't more customer parking be provided at the site currently if the cause of congestion is absence of customer parking? That's what's being complained about over and over. The reason that this is this project is being proposed is because there's inadequate customer parking. Well, if you can fit 166 spots in the building with valet parking, then why don't you just put in as much of customer parking as is needed, and then you've taken care of the problem. On the access to the parking in general question, the only modification since the last hearing was the addition of some dashed lines to indicate 3 reservoir spaces at the ramp, which the applicant insists are not required by zoning. Need I add that rooftop parking isn't required by zoning either, nor is it permitted by zoning absent a discretionary approval. This is a special permit, and the applicant has to endeavor to address the board's concerns that the proposed use will not be proposed use will be detrimental to the character and safety of the neighborhood. On the access question, the arrows indicate the elevator is for entry and egress, as is the ramp. What will prevent the congestion at this tight and overtaxed entry point discussed at both prior hearings? The south entrance is being used to allow access to 137 parking spaces for customers and for test drive cars, with what we are told is 210 trips per day, 32 trips per hour. That's one trip every 2 minutes. And we are told that the elevator can travel to the roof in 14 seconds. That's great. But if the customer has followed the arrows to the ramp into one of 3 reservoir spaces located up to 60 feet down the ramp into the cellar, how will it make its way to the speedy elevator to the roof, where it will obviously have to go because there are only 20 customer parking spaces in the cellar? Does it drive down the ramp, or even the valet drive down the ramp, drive around the display cars, and enter the elevator at the cellar, from which we need 24 seconds to the roof, plus the throughput time from the ramp reservoir spot and around the parking lot to the elevator door? And is the elevator waiting in readiness? Is it already down there? This is described in the tech memo as, quote, queuing internally in the cellar while the elevator processes access to the roof. Frankly, it all makes no sense. Trip generation analysis assumes no unscheduled drive-ups for browsing the showroom. Will such a customer be turned away, an unscheduled drive-up customer? Although the study assumed 100% driving customers, why does it continue to assume no spontaneous visits? I have problems believing that in normal times, someone drives up to this site to take a look at a car because they're all of a sudden in the car buying mood and they are turned away, sorry, come back tomorrow, because that's probably a lost customer. So according to trip generation at page 33 of the study, at peak hour, there is an accumulation of 86 cars at noon from sales and service staff and customers for all dealerships. I can't really tell because of the division of all those different kinds of Toyota, Nissan, or all that stuff. I can't really tell whether these are all to be accommodated in the subject parking garage and whether staff can't park at one of the off-site locations. But 42 spaces are already required by zoning, and 166 spots could fit on site without the rooftop. So again, why not just increase the employee customer parking to meet this demand? And shouldn't that, and this is a question to Tracy Benke, our environmental review officer, shouldn't that be the no build in the EAS? And that be the proposed cure for area congestion first? So that shouldn't the no build be 166 spots with customer parking as required, filling up all of that situation, as opposed to, I don't know, I don't actually know anymore what the no build is, because it's not really reflecting the same as of right as what we're seeing. And I don't know where the as of right came from. And the noise report at page 3 to 4 states that they are waiting for updated trip generation information for the roof. So then what are we reading in the revised DOT technical report if the noise report is still waiting for updated trip generation? I don't understand. The two consultants didn't speak to each other. I think they're even in the same building, same office. I note that at page 62 of the EAS, which was submitted on, this is really a note to commissioners, on November 30th and located in the seeker folder, there's a letter to DOT dated November 20th. That's the same letter as that is located in the November 30th submission folder with the title DOT Technical Appendix. So any new technical information that went into the EAS, you've seen it because it's in the regular folder that we review normally, right? Other than that, I don't believe that there was any additional data provided in the EAS on the traffic parking question. So I have way more questions, many of them repeat ones, than was offered up as answers in the submission. Simply put, after all that, how would this exact structure, as currently built, filled to brimming with parking spaces that meet code and valet parking skill sets, address the current congestion and pedestrian danger complained of? Then we can take a look at whether the lot can handle even one more space on the roof as relates to curing or increasing congestion. I would like to add that although this application is subject to seeker, this board must also make findings having to do with neighborhood impact under the special permit. Seeker thresholds, therefore, will not necessarily prevent the board from asking for further analysis, and in fact, won't prevent the board. In that regard, we should also see a level of service analysis for area intersections. So I expect that, and I think we talked about that last time. And I definitely need an explanation about pedestrian impacts with a 125 car increase on site. We are told the increase will take cars off the street and away from the other lots being used by this business. In that event, they will all be brought up the curb and across the sidewalk to this building at a rate of 1 trip every 2 minutes. Current Saturday peak hour sidewalk crossings, we were told previously, are 150 per hour. That's a lot more than 1 per 120 seconds. So there is a big disconnect here, and striping the sidewalk and putting up a sign won't fix that in terms of pedestrian safety. We will also ask DOT to consider these concerns in its analysis and protocols. And then, sorry, this is so long. There's also a noise study update on the acoustifence comment. Well, I don't disagree that this material may work in this case because I don't have any testing results. I find it strange for the consultant to argue that it is as good as other acoustical systems when recent recommendations for a very noisy drive-in restaurant directed the applicant away from this fence textile to heftier acoustical panel materials, paneling systems. There must be a reason why these different systems exist and why on highways, the New York State Department of Transportation shields residents with tall wall barriers and not textiles attached to chain link fencing. There's obviously a difference between these materials, and there's a discussion about absorption. You can also have absorption with other materials and at the same time a higher STC count. The noise report shows impulse noises up to 94 dBA enduring for as long as 1 minute or occurring 30 times an hour for 1 second each. 30 times an hour for 1 second each. This cannot be downplayed. Whatever seeker may allow for, BSA's job is to prevent a discretionary action from disturbing the peace of neighbors. Therefore, noise attenuation has to be designed to buffer this sound to acceptable 42 dBA levels. Imagine listening to this from 7 a.m. to 7 p.m. every day. In connection with another project that we've been hearing, we watch video recordings of the regular dumpster operations of an adjacent restaurant and learned indeed how difficult it is to live near such impulse noises. We will ask DEP to consider these concerns also in its analysis and protocols. We instructed the applicant to take the stackers off of the roof, but like almost everything else they were instructed to do to modify the project, they ignored us. In this case, we are being told by everyone, opposition and proponents alike, that the operations at the site are placing undue pressures on the community in terms of traffic, congestion, parking, and pedestrian safety. We are being asked by the applicant to ignore the significant toll on traffic, parking, and pedestrians that this existing facility has with its existing and as-of-right parking lot. The applicant is claiming without any scientific data to support it that their way of solving that problem is by adding 125 spaces to the building that was approved by DOB with 114 spaces, 42 of which were required customer parking. And of the 125 new spaces, 73 are on the roof for what is claimed to be customer parking, and 52 are inside for additional sales space. The claim is also that 20 of the spaces in the cellar will be used for customer parking. But in fact, there's no way for BSA to regulate any of this. All of those spaces could be converted to sales without our knowing it, or all could be converted to customer parking. Further, the proposal ignores the fact that the number of spaces in the building could be increased, as I said before, to 166 spaces as of right, and the mix of parking types could be modified to accommodate all of customer and staff parking needs. And there is this unfortunate support, I have to say this, unfortunate support for the project from elected officials, one of whom actually testified that she was a member of the applicant's, and she said it, team, rather than a representative of the community who lives and suffers from this use and cognizant of the scathing recommendation to deny this application provided by the community board. My feeling about this case is that the business has to get its act together first with its as of right use before it can come to us for any hope of a waiver to allow for more parking. I don't have faith that they will manage the tight access to the parking elevator with its 3 reservoir spaces or prevent buildup into the street with the 114 spaces currently proposed. I am also very disappointed by applicants' outright refusal to modify the project as discussed at the last hearing to provide a 30-foot landscape buffer between the residential property line and the first parking space, and to eliminate noisy stackers on the roof entirely. The building is already built, although I don't believe the ramp to the roof is. The applicant is standing steadfast and stubborn in its assertion that the planting in 28 inches of soil in a 10-foot front to back planting bed will grow to a dense forest in our sub-zero temperatures managed by an automobile sales company who has repeatedly demonstrated that it doesn't care about the peace and quiet of its neighbors to the rear or the safety of the pedestrians who now avoid this block, or the havoc on traffic and parking they cause. And just to cite a case, because I think it's probably relevant to cite case law, in Retail Property Trust versus the Town of Hempstead, a 2002 case, the Court of Appeals upheld the zoning board's denial of a special permit based on the empirical evidence that in the board's view contradicted the applicant's experts' reports. So, and that was also a special permit for parking. So far in this case, the experts' report rely on flimsy, inconsistent, unsupported, and probably unsupportable claims that the 125 car increase in parking on this site will have 0 delta negative effect on area congestion, since they will only be handling existing demand. And with that, I turn it over with apologies to Vice Chair Shanda.
You have made my task easier. You have stated pretty much all my concerns. I just want to add that, I did find the submission extremely confusing, trying to review the DOT piece of argument, and it was very upsetting to see that they were only responding to DOT cases and not at all reflecting any of the comments that was raised by this board. My concern when I read the DOT letter, my question was, okay, if you're saying that there will be less than 5 total hourly trips per cup cut during the sales hours, this parking space is going to be used by all the other Plaza Auto Mall dealers in this area. So it's not just 5 total trips, it would be many more. So they have given us a list of all the various salesperson who is going to be available on various days. If you add it together, which we shouldn't have to do, but if we add it together, it comes to more than 80 sales rep that are there on a Saturday from 7 to 4 or 7 to 8 or whatever the period is. And that would be 5 times however many. So the math has not been provided to show what will be the total number of trips that would be generated by customer parking who will be coming there. And so my question is, what will be the corresponding number of customers that will be coming to this site that would be not just be shopping at this subject site, but at all the other Plaza Auto dealerships in the area? What is the total number of test drive trips? What are the per hour from the subject site? And based on that, we need to determine then, is the drop-off area adequate to handle so many customers arriving and departing? And will one elevator be adequate for that? And the greater concern is the pedestrian flow from that location to the various dealerships when there are vehicles that are being brought in and out from the dealerships across everywhere. There's so many curb cuts along that location. So I do have a lot of concerns, and those have not been addressed. And as you mentioned, these have been repeated several times. Now, I do recognize that by providing the customer parking at the site, it will help in alleviating the traffic congestion at this location in this area, and may improve the vehicular circulation. But it is not clear from the documents that's been provided that that the total number of provides that the number for the site, which will be accessible to both subject dealers and other stores in the area. I'm not making sense with my comments, but it's basically not clear from the documents provided how that is being done, as I stated earlier. And also, I'm not sure if it is possible to monitor for us if the rooftop will be used for customer parking, because if there's a demand for more storage of dealership vehicles, then how are we to verify that? So I am concerned about that. Should we go forward with a solution that works? I still need to know how do we make sure it works. We have not received any operational plan as to how this is going to succeed, how this is going to be monitored. I agree with you with regards to the acoustic fence. Instead of that, it should be an acoustical wall, which is on the interior, and the planting bed maybe can be increased and made deeper to allow for it, provided the structural integrity of the roof can accommodate that. What I also was wondering is that the Plaza Auto has been renting additional parking spaces in the vicinity and within like 0.75 miles from the north of the Plaza Auto Mall dealership. Why can't those be used for either customer parking and you provide a shuttle, or a staff parking? Or we know of from other auto dealerships that oftentimes parking the vehicles for sale are stored outside. You have some sample vehicles at site, which is used for testing purposes. And then if customer A likes that vehicle, you put a call to your guy there and they bring the car, and that's it. If it's not that far away, it's 0.75 miles away. So why can't that dealing be done? And that way you don't have to store all the cars that you are selling on the site, and instead turn this facility primarily into customer parking. Employee parking can also be located elsewhere, because they're going to come at a fixed time. Let them be off-site, and then have a shuttle bus or a jitney to bring them to the site. That way you provide make this a primary customer holdout area with few spaces for the display of vehicles for them to pick, and the rest can be in the nearby parking area holdout. So I'm not sure why it's being done in this manner, and which is resulting in aggravating the situation more. It's too small of a site to have so many used cars for sale on display, so many vehicles, customers coming in to park, and employees park. That's too much going on this site. That's all.
Thank you. Okay, thank you. Commissioner Otley-Brown?
Yes, I feel that the chair's comments have been very thorough, and I believe, just like the chair, that we're not being given all of the information we need in order to make our determination. A lot of the assumptions are faulty. I just want to point out, just like the chair did, and reiterate that one of the most faulty assumptions one could make is that everybody's going to make an appointment. That's just not how car shopping is done. Some people do a lot of their negotiating over the phone or through email and then make an appointment to come in. But an awful lot of people literally go car shopping from dealer to dealer. Oh, I'm going to hit 3 dealers in Brooklyn today and see who I get the best price with. There is no appointment. You just walk in, you see if somebody can help you. So to totally dismiss that portion of your customer base kind of calls into question your analysis. And so that's just one point I wanted to reiterate, but I certainly feel like the chair does, that you have to give us all of the information in order for us to analyze this properly and come to a conclusion. And I won't say anything else at this point.
Thank you very much. Commissioner Sheta.
Thank you, Chair. I don't want to add too much. I believe like too much said, nothing left to add, except for I want to highlight the points that I raised and they were not responded to. I had concerns about the thickness of the planting soil. It's just 28 inches. And I had concern regarding the freeze and thaw of this thin layer. I did mention that according to the New York City Building Code, frost dips could extend as deep as 4 feet at some locations in the state. And if this is the case, and this 20-inch, almost half of 4 feet could freeze and thaw, the plants are not gonna survive. That was one of my concerns that I didn't see response to. The other thing, I did talk about the effect of the wind. So far, the planting is planned in front of what appears to be a 10 feet tall fence on top of that planting box. And if, like I said, wind blows, the trees or the shrubs or whatever is gonna be there is gonna be under huge uplift / wind blowing forces that I did ask the applicant to evaluate, and I got nothing. And I had to do like some research to see whether what I asked for is actually legit, and it's done. And I did find 2 publications actually, and too many documents that talk about the effect of wind blowing on trees and how they could break these trees and make them like fly or thrown away. So I haven't seen any response to that. In addition, the fence itself, it's 10 feet tall and it's above a building. So I anticipate that the wind force on that fence is gonna be very significant, and it's very tough to just put like a simple acoustic fence. And in the meantime, it withstands the huge wind blowing that's gonna be coming to it. One of the points that I did raise, I'm not sure, maybe during, not the last hearing, maybe the hearing before, I did talk about why the applicant cannot simply build a subcellar. And at that time, I've been told that the groundwater is high, and it's gonna be a submission on that. In this submission, as a part of the proposed plans, I got 2 drawings. If you give me a minute, I can like grab the numbers of these 2 drawings. This is these are they are dated 11/19/20, and this is B-10000 and B-10100. These 2 drawings are coming with boring logs, and the boring logs indicate that the groundwater is about 25 feet below sidewall. And my point is, if groundwater is 25 feet, the applicant could have easily built a subcellar. He got 25 feet. He could have put the lowest floor slab at 24, split the 24 into 2 floors, 2 subcellars, and then just build the footing, the spread footings underwater. And it could have been like an easy job to do. The cost from that wouldn't be like that significant. So actually they gave me something that made me like stick with my idea. A subcellar could have been a solution to this with a reasonable cost. So far, I believe we should put this case like to rest, and we looked at enough. And if the applicant is not responding, we're not going to be like begging or pushing for information. I believe we should close and vote on this as soon as we can. Thank you.
Okay, I appreciate that. Thank you. Commissioner Shabeta.
Thank you, Chair. I thank you for that very detailed review. I just want to mention again that I don't think it meets 7303A and C. I think that I see that that 70, one second. That in 7349, part of what our findings shall be is that the roof parking shall not impair the essential character of the adjacent areas. I don't believe that this meets that finding. I don't believe anything in the submission, in the last submission, properly addresses that, especially with regard to the residential homes in the rear of this building. I don't think that, you know, my advice to the applicant would probably be, if there is a submission, if you want to address the statements made, I think you should do in a submission. I don't think that a very long hearing is going to be of much service here.
I agree. So my comments were really long. It wasn't an invitation to have each comment addressed with arguments. We're looking for data, and if you can't give us the data, if you didn't submit to us the data, you have to submit to us the data, because that's what this is all about. It's not about arguing that we don't know how to read the data, et cetera, et cetera. Okay. Because in fact, for the benefit of the court, we in do know how to read the data. This is a panel of extreme experts with a lot of experience reviewing parking garage analyses, traffic reports, pedestrian analyses, working with the Department of Transportation on these analyses, and a lot of experience with the various consultants who submit to us, just for the record. Okay, thanks everyone. Let's on to the next.
Item number 31, 2019-35 BZ, 235 Beaumont Street, Brooklyn.
We were provided with DOB approval of the non-substantial improvement review, which was, this is a flood zone 11. Building height was lowered by, the overall building height was lowered by 1 foot 4 inches. We talked about the building being too tall for the neighborhood and that we needed justification for it, because the tallest of the adjoining properties up until then was 34 foot 10 above curb level. And as now proposed, the building is very tall at 36.5 feet above base plane, which is actually 8 inches above average curb. The DOB approved drawings have a base plane of 7.34. So this is again another one of those, which datum did you use for these different submissions? How did the base plane increase to 8.76 from 7.34? That's about a foot, somewhere in the foot. That 2013 set, again, just after Sandy, of DOP approved plans do not show compliance with Appendix G or elevations in NAVD 88. So I'd ask, are the elevations shown in Brooklyn datum? Please explain. No matter which datum you use, the first floor is shown on the new plans as higher than the DOB plans if you use the elevations as opposed to the measurements. But I do see, compared to what our comments were the last time, I do see that the streetscape drawing was revised now to reflect the rather enormous house recently constructed next door, which was apparently built, though we haven't had a chance to verify that in the field, pursuant to a BSA approval, which is 2016-4219 BZ. I'd like to note to our compliance officer, Ted Ricketts, to check the approved plans against the as-built condition. I don't see Ted here on the, is Ted here? Yeah, he's here. Okay.
I'm here, Marjorie, sorry.
I see, sorry, I saw compliance and I was looking for Ted. So I see Ted Ricketts, our compliance officer. So if you could check when you can, that's sort of a drive-by against the approved plans when you do a site visit, okay?
Not a problem.
4219. Okay, thanks. I'm still confused about the scope of the work. The second floor plan shows no work and no new partitions, but the section 1-1 shows all new joists and flooring at the second floor and second floor roof, onto which is added the new third floor. This may be an affectation of the PDF that's getting different levels of shading. So maybe that's the only issue. Otherwise, all of the comments were addressed. So to kind of cut to the chase, it's really that I don't think the elevations are in NAVD 88, so that needs to be corrected. Other than that, you know, I think the building's tall, but there's another building that's just as tall next to it. So what are we gonna do? Okay, so Vice Chair Shanda.
Yeah, I'm satisfied with the revisions made to the plan. I have no additional comments.
Commissioner Otley Brown?
No comments.
Commissioner Sheta?
I have nothing else to add. Thank you.
Commissioner Shabeta?
And nothing further from me, Chair.
Thank you. That's it.
Okay, so now we're going to recall decision item number 12 from yesterday, 2020-35 BZ 13618 Maple Avenue, Queens.
Yes.
And
So
we're going to reopen.
yes, to
So I'll
accept
make-
the document, right?
To accept an environmental document, correct?
It's
So
a
if-
revision. It's a revision to the plans based on a DEP approval that came in right after the vote yesterday. They changed the vapor barrier and it was under review and it was approved. So for consistency, we just had them update the plans. with
So
that.
by the change to the plans, it's just
A
information about
note,
the barrier. That's the
right?
only-
It just is the change from the type of vapor barrier that was previously approved to the new vapor barrier.
Okay,
Okay,
so we
so I
need
have
to
to,
reopen. So motion to reopen.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Hi.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Okay, so because we just reopened and that previous comment by Ms. Benke was off the record, now we're on the record. Because so you can repeat what we're accepting, revised plans that reflect what?
Sure. Revised plans that reflect the DEP approved vapor barrier change. It was a amendment to the RAP, which changed the vapor barrier type. So there is a new note on the plans reflecting that new vapor barrier type.
Okay, great. So consider it accepted and now, right? So we don't need to do anything else. I just want to make sure that our council is on board. Okay. So
Yes.
then a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Hi.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
We don't have to revote, right? No.
No. And then we
Okay.
can also, because we did receive the,
I was just going to ask you.
we can also do that. Let's do that. So they don't have to wait.
Okay, so we're recalling item number 15, 2019-292 BZ 4162 Barron Street, Queens. So a motion to reopen?
Yes, motion to reopen.
Chair Perlmutter? Aye. Vice Chair Chanda?
Hi.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Thank you. So on this one, I'm not sure that we had to reopen because we didn't vote on this one yet, but this was yesterday.
Oh, sorry.
Yeah, so this one was yesterday's and it was in the decision item list and we decided to defer the decision because we needed a resubmission on the drawings to show, oh, sorry. Sorry, not sure we got everything. Daryl. So we also needed the elevations on the drawings to be changed, not just those two, the two things that were submitted, which was the form and the survey. Those two things needed to be done to show that NAVD 88 was used as the site elevation datum that was provided to FAA to determine the final height in the determination. They previously, because we didn't know until recently that AMSL and NAVD 88 are the same, they changed the drawings, their actual drawings, to show two values, one for NAVD 88 and one for above mean sea level, right? So unless they submitted, and they should have realized that too, unless they submitted those updated drawings, I don't think we're done yet. This is for their benefit. The building's going to be too short, I think, because they translated from above mean sea level or mean sea level at the Throgs Neck Bridge to NAVD 88 on their drawings. So I don't know if they're listening, but you need to reach out. Please do it with a phone call. Emails are just really not efficient. And we'll now it's open, we'll put this on for afternoon call. They need to make the changes now to their own drawings. All the drawings that show the elevations everywhere have to only be in NAVD 88.
Oh, cool now.
Okay, thank you.
Okay, so so now I finish? So this
Yeah.
concludes the public review session. We'll now commence with the public hearing.
Oh,
on
okay.
November-
I just want to say it's 10 to 12 and we know that this hearing is going to take a while. Why don't we take our 10-minute break now and resume at 12 o'clock? Okay?
All right.
Is that okay with everybody? Otherwise, there won't be a time for a break. Okay, so we'll come back in 10 minutes at 12.
At 12? Okay.
Yeah. Can the commissioners join us, please?
I'm back.
Okay, all here.
We're live?
No,
We're not live yet. Yeah.
We're live. Recording pause.
Oh, I got a promotion. I'm executive director.
I always change your name. Oh, I did? Oh, sorry.
Sorry, Carlo.
Sorry. Okay, you. I could have made you.
Queen for the day. Aging myself. We ready? Not yet.
I see a recording paused. Who's running the show? Carlo?
So Kurt was there.
Steve.
Steve,
Oh,
can you?
okay.
There we go. We're recording, right?
We're good?
Yes.
Okay. So good morning, good afternoon. This is the public hearing for December 15, 2020, 10 a.m. session. Next item is new cases. Item number 28, 2019, 176A, 17 Easton Parkway, Brooklyn.
Okay, so we need. I don't see Mr. Cheney on here. Who's
Hi.
on behalf of the appellant?
So Mr. Cheney's computer froze,
Oh,
and I believe he rebooted and said he may be lost in the stratosphere somewhere.
You could call in though, I think, right, Madam Chair?
sure. We
I
can
know
call
that's not,
to make a presentation like this.
yeah, that's a little problem.
Madam Chair, it's Ken Fisher. While we're waiting for Frank to get it back on, he had also, I think, emailed the deputy.
Yeah, for the, I'm sorry, the rabbi.
Wanted to say is the order of speakers is the show of the, thank you for renaming yourself, or maybe someone else did that. The order of speakers is the domain of the applicant and it's their show. This is not run like city planning where you have to submit speaker order. Oh, there's Cheney. Okay.
Yeah,
All
so he wants the rabbi to speak first, so.
I don't know, but Tony, what I want to say is
No, I'm sorry, yes.
first is completely up to who's ever leading the team. This is not like city planning where we have to see the order of the speakers. So I'm not even going to look at the order. They can even change it spontaneously if they don't think that it should be that order. So I don't know if Mr. Cheney can hear us because he's still connecting to audio. But anyway, so he can begin and then he can hand it directly over to whoever he wants to speak. Because we can't manage also their speaker order.
So, Madam Chair, why don't we proceed directly with the rabbi since we had asked that she go first
So,
Hi, good morning.
Sorry?
Sorry, I cut you off. Sorry, go ahead.
Please state your name for the record.
Hi, I'm Stephanie Colin. I'm the rabbi of Union Temple of Brooklyn.
Okay. No swearing has been done, so you can proceed.
Okay, thank you. Well, first, happy Hanukkah and happy Merry Christmas and happy holidays. And I hope everybody and their family are well and healthy and safe in these days. So good morning. My name is Stephanie Colin, and I'm the Rabbi of Union Temple of Brooklyn. I'd like to thank the commission and the staff for holding this hearing today. I'm honored to be joining you this morning and grateful for the opportunity to share my rabbinic perspective on a matter that is so important to the Jewish community, the Union Temple community, and to our Brooklyn neighborhood. You might be wondering why a member of the clergy is part of this conversation about building use. But the truth is, this conversation about what we can and cannot, what should and should not happen in our building is critically important and quite fundamental to the work of faith communities in these dark and difficult days. What we do, how we serve our people, how we act as a gathering place, the role we play in the larger community, and the way Judaism participates in civic culture and life matters now more than ever. Americans are experiencing one of the loneliest times in history. The pandemic we are currently facing and the isolation required to keep us all safe only exacerbates what is already a devastating phenomenon in our day. People are lonely and isolated through trauma and loss, things we've seen way too much of recently, through challenges and job loss and the regular ups and downs of life, even through our joys. We are a country of the lonely. Being part of an active and vibrant and connected community, particularly a community of faith, is a proven antidote for the destructive nature of loneliness. Why? Because faith communities, and for me and for us, this is obviously through the lens of Jewish community, are charged with the profound responsibility of helping people find meaning in their life through their life journey. Helping people connect to one another in real relationship within the Jewish community and across lines of difference. Helping people be part of making this world a kinder and more just place, inspiring minds and filling hearts, and helping each of us live lives of purpose. These are our jobs as a Jewish community. So you might be thinking, that's great, Rabbi. So lead them in prayer, give tzedakah, run a Hebrew school, and eat some lox every once in a while. I am here to share with you the Jewish community, our congregation, and the purpose of faith institutions is so much more than how you might define Jewish life, and not just what should happen, but honestly what must happen inside a synagogue building. Historically and today, a synagogue fulfills three roles within a community. We are a Beit Midrash, a house of study. We are a Beit Tefillah, a house of prayer. And we are a Beit Knesset, a house of gathering, where the people gather to figure out what's meaningful about life, what's important, how to live a worthy life, how to educate our kids and walk a path that we can be proud of, how to relate to this world around us, how to care for the most vulnerable. It's a gathering place for breaking bread together, for having our minds opened through learning and art, and having our hearts comforted and lifted through laughter and music and hope. The Department of Buildings team has suggested that the kind of events and experiences we are talking about cannot be allowed because they aren't Jewish events and they aren't geared toward Jews. I want to recognize that I believe they don't mean to offend. But this idea that the city should be able to decide what is Jewish enough is really problematic. At a time of growing anti-Semitism, we want to lean into being part of the vibrant life of Prospect Heights, Brooklyn, and beyond, inviting people in and having meaningful and humanizing experiences together. Judaism is not a set of texts in a book. It's a path on which we travel, a garment that we wear as we walk this world, how we engage in all that we do, from the mundane to the most holy. Judaism is not a set of what is and what isn't Jewish. It's a process of how. How do we live a meaningful, worthy, purposeful, moral, ethical, beautiful life? And that touches everything, and everything touches it by design. For example, dismantling systemic racism and asserting that Black Lives Matter is a Jewish issue, in part because we have Black Jews and Jews of color in our community, and in part because we insist on living in a world that is just, compassionate, and equal for all people. You might not call that a Jewish issue, but I guarantee to you that it is. And so when it shows up in our sanctuary as a program, that is holy work. You might think that a concert is just a concert, but music that lifts our souls and helps us transform our lives from the transactional to the love-driven is holy work. Comedy and laughing together, which brings levity to heavy hearts, is holy work. Political conversations and learning from authors helps us discern how to live our deeply held Jewish values in the public square and is holy work. Filling a sanctuary with people who have a common bond is holy work, as it challenges the notion that individualism equates to loneliness. It's all Jewish when we engage in it through the lens of Torah. By partnering with folks like Murmur, you can see from their materials, they share our values and our mission aligned in the way that they come to this work too. We better deliver on our obligation to help people elevate their lives, make this world a more just and compassionate place, and be connected to one another in a web of meaningful relationships. So you might be wondering, why can't you just do all these programs by yourself? Well, we've got a really small staff, and I'm trained as a rabbi and a community organizer, but not in event planning. So we partner with all kinds of people. Brian and others like him create not just content, but context for figuring out how to live these lives we're in a way that matters. We want people to have their lives touched by art and humor and music and challenging ideas. We need it. It's our sustenance. It is part of Reformed Jewish life, and we relate to it through a lens of Jewish tradition. A person new to Jewish life may never come into the building for prayer. It could be too intimidating or something they don't even know that they are interested in, but being there for art and culture and community may spark in them something they didn't know was there. And maybe they find me or our preschool or our 20s and 30s and LGBT or interfaith or justice work. And they find that religion is not something far from them, something old, but rather it is an existential value add for them and their children. And when that happens, we don't only change one life, but the ripple effect of their participation can change the world. Thank you so much for your time and for listening to my words and hearing us out on this morning. I appreciate it so much.
Thank you. Okay, next speaker, Mr. Cheney or Mr. Fisher, you decide who speaks next.
Mr. Cheney, if you need to unmute, it looks like your audio is by telephone. Press *6.
Okay, can you hear me now?
Yes.
Yes.
Okay, good. I apologize. Something happened with my laptop and I lost the video, so I trust you can at least hear me. I had prepared remarks for this hearing, and they clocked in at about 10 minutes. But while you were discussing the other items on the agenda and during the break, I tried to add in some responses to the points that were raised by the commissioners. So with your indulgence, I'll go through my prepared remarks with these additions. I don't think they'll be more than about 12 minutes long. And anything I can't get to, I trust either my co-counsel Ken Fisher or Mr. Stein, the president of the temple, will be able to cover. And anything we don't, we will follow up with the commission to answer those comments. My name is Frank Cheney. I'm counsel with the law firm Rosenberg and Estes, representing the Union Temple of Brooklyn in this appeal. The first thing that I'd like to address briefly addresses DOB's reliance on the 2006 53rd Street catering case, which in their November 30th letter, they describe as analogous, but it is not analogous. The facts and circumstances of that case are utterly different and distinguishable from this case, including as just a couple of examples. In that case, the subject building was located on a narrow residential street, almost entirely occupied by two-story semi-detached houses, unlike here, where the temple is located on a very wide arterial street in the middle of a cultural and transportation hub, attracting millions of visitors per year. In that case, the catering facility operated on, quote, multiple consecutive days, unquote, for a total of 320 events over a 2-year period, for an average of 1 event every other day. In contrast, here, there were only 110 events over a 22-month period, for an average of 1 event every 5 days, less than half the number and half the frequency of the catering events in that case. In its resolution in that case, the board acknowledged that frequency is a relevant factor and cites DOB's own acknowledgement that an income-generating accessory use such as bingo could occur 1 or 2 nights per week up to a total of 104 times per year and still be considered incidental. Therefore, by DOB's own standard, the 110 events spread out over nearly 2 years at the temple is clearly incidental. That DOB issued 6 TPAs for the events is clear evidence that they agree. As the courts, this board, and DOB all agree, the accessory use determination is fact-driven, so that the factors to be considered will vary depending on the facts. And as the board stated in its resolution in the 53rd Street case, quote, no prior determination will ever be a perfect precedent as to a different set of facts, unquote. The second thing I'd like to talk about is TPAs. DOB says this is the solution to our problem, but it's not. Setting aside the disconnect between DOB on the one hand arguing that the events can't possibly be an accessory use, and then on the other hand saying they will nevertheless allow them, the fact is that the events have been operating under a series of TPAs from the fall of 2018 until the last TPA expired in February, just before the COVID lockdown began and all TPAs were suspended. Despite having a TPA, DOB nevertheless issued a zoning violation against the temple, calling the events an illegal occupancy as a commercial theater. So problem number 1 is that, as demonstrated by DOB's issuance of a zoning violation, despite having also issued a TPA, TPAs and ZRDs are not the same thing. And having a TPA is not a substitute for having a ZRD, formally acknowledging that the events are an allowable accessory use and not an illegal commercial theater. We had a TPA and it did us no good. We still got a violation. We need the ZRD both to cure the existing violation and to ensure there won't be any future violations. Problem number 2 is that what DOB now proposes is to use the TPA process to determine in its sole discretion in advance whether any given event will result in noise, lines, crowds, pedestrian and/or traffic congestion, or overflow demand for parking. And if it does, no TPA will be issued. Setting aside the question of how DOB can make such a determination in advance, this is not the purpose of public assembly permits, and it's not how the process works. As stated in TPPN number 7 of 1996 on the DOB website, in its place of assembly guide, and in its November 30th letter, the purpose of the PA and TPA process is to ensure public safety. There is nothing in any of these things to suggest that the issuance of a TPA is conditioned on a finding that there will be none of these so-called objectionable influences. Also, the TPA application form does not require the provision of any information that would enable DOB to make such a finding. This ties into the incidental condition of paragraph B. As we have shown, from May 2017, when the events began, until December 2018, just after the ZRD was submitted to DOB, a total of 87 weeks and 611 days, the events occurred on just 110 days, 18%, for an average of a little more than 1 per week. And on only 35, less than half of the 87 weeks. For periods up to 2 months at a stretch, there were no events at all. We also showed that when events were held in the sanctuary, they utilized only 32% of the temple's floor area and a mere 15% when held in the 3rd floor ballroom. All of this information is provided in detail in the ZRD and the ZRD appeal, and was referenced but not restated in our statement of facts. Will be happy to pull that information out and submit it separately as part of the application. DOB has never disputed these facts or even so much as discussed them. Instead, they have cited to a shifting array of other factors as to why the events are not incidental, key among them that they are not, quote, related to or, quote, ensue from a house of worship use. But there is nothing in the text that explicitly or implicitly imposes a condition of relatedness. Reading such a condition into the text is contrary to the entire concept of accessory use, which is predicated on the fact that an accessory use is so unlike or so dissimilar to the principal use that except for meeting the three-pronged test, it would be non-conforming. But if an accessory use were required to be like or similar to the principal use or to serve the same or a similar purpose or function, it would itself be a principal use, not an accessory use. Nevertheless, DOB sticks to its interpretation, citing such things as noise, crowds, lines, traffic congestion, and lack of parking as reasons why the events are not like the temple and therefore not incidental. The only evidence DOB provides for any of these alleged impacts are the two 311 complaints, one from 2.5 years ago and another from more than a year ago. Two complaints about 110 events over a period of 2.5 years hardly amounts to the insurmountable hurdle to making the incidental finding, as DOB puts it in its November 30th letter. After the first complaint in 2018, the temple spent hundreds of thousands of dollars soundproofing the sanctuary and the ballroom, as a result of which there has been only the one complaint in late 2019 and none since. In any case, the two complaints about the events are clearly incidental to the much more numerous complaints by the residents of the adjacent condo about the temple's as-of-right principal and accessory uses during the 8 years after the condo was built and before the first event was held. Mr. Stein will address what we believe is the primary reason why we've gotten these complaints from the adjacent condo. This brings us to the rather astounding assertion in DOB's November 30th letter, referenced by the rabbi, that another way in which the events aren't related to the temple and therefore can't be an accessory use is because they, quote, lack Jewish content and are not geared to Jews or have any other relationship with the temple other than revenue generation. So what exactly makes any given event Jewish enough to be considered accessory to the synagogue? Must the content be Jewish? Must the musicians, comedians, and book authors be Jewish? And who will be the arbiter of what constitutes sufficient Jewishness? DOB? If this were a church instead of a synagogue, would DOB say that the events must have Christian content and be geared to Christians? That DOB would even suggest this as a legitimate line of inquiry is concerning. The last point I'd like to address is the assertion by DOB that revenue generation is the sole benefit to the temple, and that this is not enough to meet the paragraph C substantial benefit condition. Setting aside that the temple also realizes a non-financial benefit from the events, there is nothing in the text that even remotely implies that the benefit may not be entirely financial. The text only requires that there be a benefit or even just a convenience, either of which may be financial or non-financial, and which may flow either to the owner or the occupants or the employees or the customers or the visitors of the principal use. Given such a wide open formulation, it is clear that this provision is intended to be permissive rather than restrictive. And it's why, as noted by the Southern District Court in the Third Church of Christ Scientist case, the New York Court of Appeals has affirmed, quote, a loose standard for making the accessory use determination, unquote. In the 53rd Street catering case, both the board and DOB acknowledge that activities can still be accessory even where the sole purpose is to generate revenue to the principal use, such as hosting bingo and Las Vegas nights or renting their facilities for events. The fact of the events being organized and managed by Murmur a for-profit entity is not ipso facto disqualifying. The 1210 definition clearly anticipates and allows for an accessory use to be in separate ownership, provided it is operated and maintained substantially for the benefit of the primary use. But the temple is not a for-profit, and their objective is not to maximize profit, but merely to generate sufficient revenue to help maintain the building and support its mission. Per the service provider agreement with the temple, Murmur cannot simply stage as many events as they want. They cannot have events on Shabbat from sundown Friday to sundown Saturday, nor can they have events when there is any other activity going on anywhere in the building, b'nai mitzvahs and wedding parties, community town halls, for example. Plus, as we have demonstrated, we have a 2.5-year history of the events occurring only 17% of the time, on average, a little more than one per week, but for long stretches up to 2 months, none at all. With that, I'll conclude and allow my fellow team members to speak, and I think that will address some of the other issues brought up by the board in the review session. Thank you.
Thank you. I just want to just ask directly to someone to address the first question that we had, which is that Murmur advertises the events with making no mention of the fact that the venue is.
Yeah, I'd be happy to respond to that, and that's not actually true. In the About page, when you go to the website and you click on the About page, the very first sentence on the About page says, quote, Murmur hosts events at the Union Temple of Brooklyn. It clearly states that the events are at the Union Temple. And then in describing, yes, granted, they describe the sanctuary as the theater, and they describe the ballroom, which is what it is, as a ballroom. But they also describe it as a religious facility, clearly. Towering stained glass windows and an ark. So I don't think they're trying to hide anything or pass this off as something other than it is.
Sorry, this is very strange. I see Commissioner Otley Brown, just 1 second and then you can. I went on on their Facebook page. There was no mention of it being the Union Temple. It said they called it the theater, and and there was actually no mention other than they have stained glass windows and an ark, whatever that means to people, because I don't know what that means to people.
Yeah.
Wait,
well,
please, Mr. Cheney, please wait for me to finish speaking. And then
okay, sorry, I don't have the video, so I can't see. I can only hear.
But you can hear. When I finish, then you can speak. Okay.
Okay. Yes.
So the website that I looked at and the Facebook page said nothing about the temple. It only said it was the Murmur Theater, and it described the ballroom space and so on as having stained glass windows, none of which mean, and whatever an ark is, because who knows what an ark is, and stained glass windows are in Masonic temples, for example. Other buildings that are arguably not religious have stained glass windows. But aside from that, when you look at the comments in Facebook, and I believe also in Instagram and maybe Twitter, the people who attended these events were unaware that they were going to a religious building. They said, I had no idea this was going to be in a religious building, not a venue, like that. So they're obviously reading the same version of the website that I was reading, and that the website may have been updated in the last day or something, is problematic. So that's the first thing. And then I had another question, which I will ask later. Okay.
Okay, I would just say that the Murmur website I can't speak to what their Facebook page says, but their website clearly states, as I said, that the events are at the Union Temple. In any case, I would say that how Murmur characterizes the venue on their website or on their Facebook page is not determinative. What determines whether or not the events are accessory is not what Murmur chooses to describe them as on their website. It depends on the facts. It depends on the extent and the frequency, which we have clearly shown are incidental to the use of the temple. So I think that if you want to talk about, now, could I just, I'm sorry, if I may just finish my sentence. If we're going to say, for the sake of argument, we want to say, well, how Murmur, what words Murmur uses to describe or characterize the venue on their website is a factor to be considered, I would just say that that factor has to be considered in conjunction with all of the other factors. I would just say it's not even the most important factor.
Okay, I'd like to recognize, I think Commissioner Otley Brown had her hand up first and then Vice Chair Shanda. Go ahead. You're still muted, okay.
Shouldn't there be, here's my question or comment. It's not so much at what the Murmur website says or doesn't say, although I will agree with the chair that it wasn't until I actually looked at the Yelp comments that I realized that the concert I was interested in going to was at that synagogue. So there was no connection from Murmur at the time that I was looking, which was probably a little over a year ago. But anyway, shouldn't there be a connection between the type of use and the religious entity? Because if not, then why not just put a little grocery store there? If it was clearly just revenue generation being the justification of being an accessory use, one would think that there should be some kind of a relationship between the primary use and the accessory use. And I'm not seeing that relationship here between the concert use and the spiritual use of the synagogue.
Okay, and thank you. And then Vice Chair Shanda.
I actually looked at the website and I did see what Council Cheney is saying, and I think I shared that link with Madam Chair. It does say that, that's all I wanted to say, that it hosts an event at the Union Temple. I just want to add, I mean, I haven't made any decisions, but I do think that the role of place of worship has changed significantly, and it is, I mean, not changed. It is definitely, many of the place of worship is trying to cater to the community and the community needs, and they vary in different ways. So what may work and what we may idealize as one form may not work. I mean, there are places of worship that have soup kitchens. They have pickup of groceries in boxes, and maybe that's free, maybe it's for a donation. There's so many ways of it. So how do we connect the link between various things that place of worships do to serve the specific community need? It's an open book. That's just my feeling. I'm not saying that's an opinion that everyone should have. So I'm open to the discussion on this.
Okay.
But I would still say I would like the appellant to provide a stronger argument of the connection with what Murmur's function is and how it works with the synagogue's larger goal. And I appreciate what Rabbi had said, but I would like that to be defined much more clearly.
Okay, thank you. And I also want to pick up on Commissioner Otley Brown's comment. why not then a grocery store? We've actually even been confronted with things like, why not a bagel factory? Why not, because you can talk about cultural references, you can do all kinds of things like that. There's got to be a place at which it's not all encompassing. Otherwise, every religious institution would have, could have major commercial establishments attached to their locations and claim it's accessory to a community facility in the residence districts. There's got to be some way of having parameters. So, okay. Oh yeah, Commissioner Shabeta, go ahead.
So I wanted to follow up on that. When I think of bingo night, I think of bingo night at the church, and that's how it's advertised to me. Where you are, and with reading these reviews, most people didn't know that this is related in any way to the temple. Some people thought it was just an auditorium or a school auditorium. There needs to be a certain type of, I don't want to say like when these things that affect the community are usually known to be done by the religious institution or community program. That's not what I'm seeing here.
Right. And, I do want to say there is another thing that maybe DOB has to be addressing in its analysis generally. New York is a big place. We have many, many, many happily and still hopefully artistic, let's say artists of all different disciplines. And there's arguably a shortage of venues for the artists, right? A shortage of inexpensive venues and all of this. And New York is a place of culture. And so these religious institutions, many of them have huge sanctuary spaces that can host, several hundred people. And so they're kind of rare space opportunities to host cultural events. So, maybe this is a question really for city planning. I think probably it's a question for city planning. To what extent should those cultural events be permitted to operate inside of a building that is ecclesiastical in nature, so that the cultural community of New York can take advantage of these very, very extraordinary venues and not only have to perform in theaters, of which there are a few, right? So that's almost like a public policy question, and I'm not sure that we can answer it or DOB can answer it. I think it's actually a city planning issue that should be answered. And I really, we're supposed to have a city planning liaison participate in these hearings. Or in these projects. I wish they would. They get notified for a reason. Maybe that's the next step. We should always bring in the liaison to participate in these interpretive appeals. Okay, Mr. Cheney, go ahead.
I guess I would just say, because I do want to allow Mr. Stein and Mr. Fisher time to respond to some of these. But I guess I would go back to the comment made by Commissioner Chanda during the review session with regard to her experience attending Indian and other world music concerts at St. John the Divine, that there are many examples. We provided 23 in our ZRD and the ZRD appeal. Of houses of worship which have concerts, not just concerts, they have theater, they have dance performances, they have artistic performances of all types in their sanctuaries, their community houses, and their other facilities. And as Commissioner Chanda noted, they often have little to no overt, obvious religious connection to the house of worship. And yet, as the board itself stated in the 2006 53rd Street case, they acknowledged, and I think you do acknowledge, that houses of worship all across the city allow their spaces to be rented out for events. And on that point, let me just stress again here, because we have said this over and over, and I don't know why it's not getting through, because DOB, even up to their November 30th letter, keeps repeating that Murmur has a lease on the space, that Murmur is a leaseholder, that Murmur has a leasehold interest in the property. That is just simply not true. We have said it over and over again. That is not the case. Murmur has a service provider agreement with the temple, as the rabbi explained, and I think as Mr. Stein will also explain, to provide a service that they were ill-equipped to handle on their own. And that is all this is. They are providing a service. And clearly, there's the 1210 text clearly anticipates and in fact allows for third parties to be owners of the accessory event. Paragraph C clearly states it can be that the two uses can be in the same ownership or separate ownership. And if they're in separate ownership, clearly then a third party can be the quote unquote owner of the accessory use. Now, Murmur doesn't own anything other than the name of their company. They have no leasehold interest in the property. They don't own the property. They don't have an unlimited capacity to utilize the property. They don't have exclusive use of the property. As I said, pursuant to the service provider agreement, they're not allowed to just have as many concerts as they want, as often as they want. And as the record shows, they don't. I go back to what I've said before. Since late 2018, DOB has issued 6 consecutive temporary place of assembly certificates. The last one expired right before COVID shut down. It has not been renewed because there were no events to renew it for.
Okay, Mr. Chan, can we just move on, because we've had that and I'm afraid we're getting repetitive and we've been doing this for 40 minutes, okay? So
yep.
I would like you to give us, I didn't find in the materials a copy of that service provider agreement. Maybe it's there, but I didn't find it. We had a lot of trouble reviewing the materials. So it was very complicated. And also, as I said, we need backup on your claim that there are so many other locations that have allow this type of music to be performed there. I only mentioned St. John the Divine because that's my experience, and the other places that I've been play organ music and things like that. So, you know, those are much more closely related to what's actually going on in the institution. So you can't just come out with this bold statement that lots of places do it. You actually have to give us backup, and you have to give us the relationship. You know, is it remote? Is it similar in structure to what this institution has with Murmur, or is it something else? The idea is this a common occurrence in the same structured in the same way? So that's the first thing. I see Commissioner Sheta's hand up. Please go ahead.
My intention was to ask whether we have a copy of that service agreement. I couldn't see it in the folder. So if we don't have it, is it possible to get a copy of it? That was the first thing. The second thing, as far as I understand, a service agreement means that let's say I contract somebody to do a service at my facility. They come to my facility to perform that service, and regardless whether they find something to do or not, they charge me for it. But this is not the case when it comes to the relation between the temple and the performer, murmur. It appears that they work together. This is kind of a partnership, not a service contract. So I'm not sure how we classify in this as a service providing relation.
Okay. And you don't need to answer this question now. We need it answered in the submission. I don't want to have everything kind of answered on the fly, in part because it takes too long. I think unless you have others who need to speak, we should go to the Department of Buildings to hear.
May I be permitted to speak, Madam Chairperson? If I can beg your indulgence, my name is Jeff Stein. I'm the president of Union Temple.
Okay.
I have prepared remarks, and I think that they will be helpful if we could take a few minutes. Is that okay, Madam
Yeah,
Chairperson?
Please don't repeat what's already been said. And also, we've reviewed the many pages. I don't know if it's hundreds, but close to hundreds of pages in the submission. So please only add what we don't already have. We presented questions. I know you didn't have any time to respond to those questions, but please, to the extent that you're repetitive of what we've already read, no need. Go ahead.
I will try not to be repetitive, but I would like to be able to give you the perspective of the trustees and the officers who have the fiduciary responsibility to try to preserve and keep the temple alive and functioning. The first thing I really like to make sure everybody understands is that the building, 17 Eastern Parkway, was built as a community house, not as a temple. And the auditorium, the first floor, was built as an auditorium, not as a sanctuary. It was intended 100 years ago that the corner lot be the sanctuary, but because of the Depression and the war, that was never built as a sanctuary. So we use the auditorium space as both a sanctuary and an auditorium, but it was built as an auditorium, and the building was built as a community house, including 5 floors of an athletic facility on the top floors. So we've always viewed it as a community space, and we use it that way. I've been a member for 35 years, and in all the years that I've been a member, for decades, we have used the spaces for a B'nai Mitzvah, for marriages, for Sweet 16s, for birthdays, for holiday parties, for town halls, for meetings, for celebrations of all kinds, with loud music, with congestion and people coming to events. There was never a complaint in the past. When we sold the lot on the corner to the co-op, I'm sorry, to the One Grand Army Plaza condo, I don't know if you realize it, but we obtained a condominium unit in the bottom floor on the street level, which is a use group non-commercial use, and it connects the condo space to the 17 Eastern Parkway space with a new elevator unit that allows the condo people to enter the 17 Eastern Parkway space to go to the gym. So that, because of that, which was known to everybody who bought a condo unit, that space sound clearly traveled between our building and their building. But that was a known effect that anybody who bought the condo knew. The first complaint we got about the noise was well before Murmur, and that was when we were using our spaces for the parties, the Sweet 16s, the B'nai Mitzvah, things like that. So we soundproofed everything. We soundproofed the third floor social hall. We soundproofed all the stained windows and closed them up. We put in air conditioning. We put in an air ventilator unit. So all of that, since we soundproofed everything, there have not been any complaints about noise from anyone. And that was an enormous expense to us, but it allowed us to have events in our space. So that I think is significant. But the point I really want you to understand from our perspective as volunteers and of people who have the responsibility to run a temple, we trustees and officers believe firmly that you have to bring people into the building. And as Commissioner Ollie Brown pointed out, some people come into the building, they don't even know that they're coming into a temple. But the point is, once they're in, they do know that they're in a temple. And I have gone to events, a bunch of Murmur events, and people have said, oh, there's this event happening, there's this party, there's this Jewish event happening. They know because we have posters up about everything that's going to be happening in the future. So we believe that we have to bring people into the temple in any way possible to get them to participate in events. And by doing that, somehow, occasionally we get new members and we get new children into our religious schools and our preschools and all those kinds of things. And there is a difference between having a grocery store and having music and other and book group. And we have half of the events at our Murmur are book events, are spoken word events, are people talking about literature, are talking about cultural events. And then when it is music, if it moves somebody's spirit, that is spiritual. That's not a grocery store. So we firmly believe that's what we needed to do to survive. And we carefully considered our options. We went to other churches that had concerts. We talked to those people. We considered partnering with those people. That did not seem to work. We considered hiring a person to run events, to bring people into the building. And we decided as fiduciaries that it was much smarter to hire an event planner like Murmur, who knew how to do this stuff and to plan the events and to bring people in. Did this provide a substantial benefit to Union Temple? We believe so. We, even if we didn't make money, and because of all the money we spent, we really did not make that much money, although we hope in the future we may. I can tell you that people have called me on the phone and said, oh, I was at your temple. So it's brought awareness of our temple to more people than if we didn't have these events. And our contributions have increased. Our participation has increased. I can tell you all of that as a longtime member. We believe that our arrangement with Murmur is a win-win. It's better for the community. It's better for the temple. There's no more noise. It's professionally run. And anything that we did in the past was not done as well as Murmur does it now. And I think that's very important for you to understand from our perspective. And if it's true that we could have done it by hiring somebody, but we can't do it by hiring Murmur, that seems to me to be an anomalous result that doesn't make a lot of sense. In closing, and I tried to be as brief as I could, Madam Chairperson. I want you to know, because I want to be clear, that we are closed. The building is closed. The building will be closed until at least September, because we had a flood from the gym on the 6th floor pool. We won't be open until at least September, and we're rebuilding. And when we rebuild, we're getting a new fire alarm. We will have a C of O. We will have a PA. We'll have everything in place that we don't have now. And in addition, I want you to know that our synagogue and another congregation are filing a petition with the Supreme Court to merge, so that in the future, by the time we open in September, we will no longer be Union Temple. We will be a combined combination with another congregation, and will be much, much larger. But we will be using our building as a religious center, just as we have in the past, with many more people. And we will have Hebrew school, we will have preschool, we will have religious services, everything we have now, but we'll be part of a bigger institution. With that, I thank you for your indulgence, and I'm available for any questions you may have, or I could provide it later.
Thank you.
Madam Chair, if I can be heard, I'll be brief, and I'll be on points that haven't been made.
This an hour, and we haven't even heard from DOB. Please,
Sure.
unless something new to add.
It is new information, and not on points that have been raised. First of all, my name is Ken Fisher. I'm a member of the.
Wait. Before you continue, Mr. Stein, you said that you spoke to a lot of different churches or other religious institutions about how they were managing their music programs. Can you please reach out to them and find out the details of how they're managing their programs? Because at the moment, we have no support for the statement that other religious institutions do the same thing as you. We actually have no actual support. We just have like touchy-feely ideas that must be happening, but we don't know it. We don't know what the arrangement is. We don't know the frequency of outside events within those institutions. So we need to establish that this is customary, and we don't have proof that it's customary. Okay, go ahead, Mr. Fisher.
Thank you. My name is Ken Fisher. I don't know where that echo is.
Yeah, you have to turn off your YouTube video.
I don't have it on. I only have the Zoom on.
Okay, your phone maybe? Turn your phone off?
Nope.
We would put it in a drawer.
Maybe a momentary glitch. Madam Chair, and Commissioners, my name is Ken Fisher. I'm a member of the law firm of Cozen O'Connor. I'm appearing as pro bono counsel for reasons that I'll explain in just a second. And I'm going to briefly touch on a few things that have come up at the hearing today, or just to call your attention to what the record shows and what the record doesn't show. First of all, since there's been a lot of references to websites this morning, I would respectfully call your attention to the website 583parkavenue.com. That is the catering company that occupies the Third Church of Christ space on Park Avenue. That is the Third Church of Christ. You can go to their about page, and you will not see any reference to the fact that it's a church. And as I think Mr. Stein indicated, sometimes it's a benefit to get people into the building without them prejudging what the experience is going to be like. But once they're in there, the fact that it's a synagogue is unmistakable. I would also respectfully call your attention to the website of St. John the Divine, stjohndivine.org, and specifically in their about page, the section entitled Space Rental, where they state that the cathedral welcomes inquiries about its use of capacious and dramatic spaces for corporate and not-for-profit events and facility references, and then goes on to describe the space. The reason I emphasize that is that in the selection of, I believe, 23 different houses of worship that we gave, we thought when we got to 24, including Union Temple, that was sufficient, but we can attempt to provide more. I personally researched those websites. I believe we provided copies of them in printout form. And the distinguishing factor of virtually everyone that we provided, if not everyone, was that I looked for houses of worship that allowed for commercial events, for corporate events, for film shots, for other kinds of events, not just ones that had concerts or even allowed people to rent them for personal parties. So, I think in the context of this, it's important, one, because we did give multiple examples. I don't know if it's reasonable to ask us to canvass the 6,000 Christian houses of worship, 1,000 synagogues, and 100 mosques in the city of New York. And even if we were able to identify additional examples, which we're happy to look for, none of them, as far as I can tell, actually publish publicly what private events or corporate events they're hosting. Now, this has particular relevance to the comparison to the Brooklyn Public Library and the Brooklyn Museum. The Brooklyn Public Library and the Brooklyn Museum, the library directly across the street, the museum just up Eastern Parkway, both of them in our zone, civic facilities occupied and used as community facilities, but both of them in our zones. Both do have corporate events. And I can tell you that from my own personal experience, having spoken on a panel as recently as 2017 on real estate development in Brooklyn, hosted by one of the Brooklyn brokerage houses. I have attended Brooklyn Chamber of Commerce events at the Brooklyn Museum. And if either of those organizations are happy, when possible, to rent their facilities out, not because it has any relationship to the work that they do, but simply because they're trying to generate the revenue and maximize the use of the space. Now, in contrast to a real estate broker renting out space in the Brooklyn Public Library, since there's been a lot of reference to the Murmur website, I also want to call your attention to what the Murmur website says about itself. It says that Murmur as an organization puts community over profit, that it tries to charge reasonable amounts of food because it's foster a sense of community, that it wants to bring people together, and that it schedules events that are intended to get people to think and to feel. So this is no mere commercial use. It's certainly no relationship to a grocery store, or there's no bank. We're not seeking to put the money changers into the temple, if you'll pardon the expression, because those would have no relationship. But as our written submission points out, every member of the temple is entitled to attend every Murmur event free of charge. That's a benefit to them, in addition to bringing people in to experience what Jewish life is inside of the temple, potentially to attract them as members, but also to foster interfaith relations, which is a fundamental tenet of Reform Judaism, as is social action. Now, the last point that I want to make just 2 points quickly. One, I told you I'd explain why I was doing this pro bono. I grew up in Union Temple. That's where I received my religious education. I was bar mitzvahed and confirmed there. But more importantly, I grew up across the street. I grew up on Plaza Street, and before that on Butler Place. My parents' bedroom window looked out on the parking lot where One Grand Army Plaza now is, and I have spent a lot of time in the synagogue during the regular course. And I can tell you that the building was designed and often accommodated an intensity of use that is substantial. The auditorium, the sanctuary, as I would consider it, holds at least 700 people. The religious services that I attended included a choir and a pipe organ, both of which were unusual, but come out of the Germanic Reform Judaism tradition. You won't find those in a lot of other synagogues, but were clearly audible to me, simply opening our window when the sanctuary was full on the high holy days. Now, unfortunately, the population of the synagogue has gone down, and as Mr. Stein told you, there are efforts underway to rebuild it. But if you look at the intensity of use with the Murmur events compared to what is permitted as of right under the principal uses, you can't make any distinction in terms of the impact on the surrounding community. A full house is a full house. A partially full house is a partially full house. A singer singing folk songs, I think there was some allusion to that, doesn't have more of an impact than a cantor singing liturgical music, particularly when accompanied by the congregation and potentially an organ and a choir. And by the same token, Mr. Stein described some of the spoken word events that are significant in this in the roster of things that have been produced by Murmur. And I would respectfully suggest that a poet or a author reading from their book and discussing the contents is not a greater use of intensity than a rabbi or a bar mitzvah reading from the Torah and then discussing its contents. So the fact of the matter is the building, the use of the building, the principal use of the building accommodates within it the uses that the temple has allowed Murmur to do. And I think it's also, look, it's worth noting also, this is a vibrant area. Grand Omni Plaza, as I'm sure many of you know, Fisher.
Can you please wrap up? Please wrap up. We've heard most of these arguments already. Please, one more minute, and then we have to move on to DOB. All right, please.
The fundamental flaw in the denial of the ZRD, aside from, is the fact that DOB conducted no factual analysis whatsoever. Their conclusions about the uses are completely speculative. They don't even refer to any of the factual material, the extensive factual material that was provided. And finally, Chair Perlmutter, because I was thinking along the same lines as you were as to whether this was a city planning issue. But before it becomes a city planning issue, the DOB has created this unenforceable, unreasonable situation because it may have made steps forward after the catering case, but it has issued no guidance, no bulletin, no TPPN, no regulations that would allow a house of worship to know what was in bounds or out of bounds. And I would respectfully suggest in closing that not only that they be encouraged to do that, but the fact of the matter is they cannot speculate on a future unlawful operation. The synagogue has demonstrated that it has allowed these events on a controlled and limited basis, and there's a presumption that they'll follow the law. This board certainly knows many instances where certificates of occupancy had conditions on them, and most recently a regulated medical waste facility where you impose conditions, and in no instance was there an obligation that on each use of it that an additional step had to be taken. So I think based on the record, the benefit of the doubt belongs to the synagogue in this case, not to DOB. We think the record is clear, and we would be happy to supplement it in any way we can.
Okay, thank you. So I need to move on to DOB, but I want to say that all we were provided with in terms of examples was a list of, as far as I could tell, 8 locations, each of them with a link to a website. And this board does not have the time to do the research for the applicant. So you need to, nobody said you had to research thousands of institutions. Just even the 8 that were given, we need support more than printing out the website. That doesn't necessarily tell us what's going on, which is why I asked Mr. Stein if he could reach back to the institutions that he was in contact with and get real detailed information about how they operate their uses so that we can determine whether it's common practice to do what everyone is suggesting here. Okay, and I don't want to have more conversation about this. We need to move to DOB, and then we need to move on to another application. So, Mr. Walker.
Good afternoon. I'm Michael Walker, Assistant General Counsel with the Department of Buildings. The issue is whether the department properly concluded that public for-profit amplified concert and spoken word events do not qualify as de facto accessory use to a house of worship. The department turns to the plain language of the term accessory use under Zoning Resolution Section 1210 and the Court of Appeals interpretation thereof, as well as the board's guidance on similar past cases to explain why it denied the classification of the proposed use as a de facto accessory use. To be an accessory use, the use must be conducted on the same zoning lot as the principal use, be clearly incidental to and customarily found in connection with the principal use, and have unity of ownership between the principal and accessory uses. The only issue for the department is whether the proposed use is clearly incidental to and customarily found in connection with the principal use. And the board has consistently recognized that determining whether a use is incidental requires a fact-specific approach. For example, in 49 East 3rd Street, Manhattan, BSA calendar number 12814A, a case about proposed accessory use off-street loading berth, the board stated, and I quote, "The board reiterates that the issue of whether a purported accessory use is minor in significance relative to its stated principal use requires a fact-specific analysis." First, appellant claims the proposed concert events use support the Union Temple mission by, among other things, perhaps generating increased membership, enriching local culture, and providing revenues that the appellant claims are necessary for the Union Temple's continued existence. However, the appellant's claims that the proposed use is a much-needed revenue stream is not relevant to the establishment of a use as accessory. In the 1824 53rd Street Brooklyn appeal about catering as an accessory use to the Vishnitz School and Synagogue, the board agreed, and I quote, "The fact that income generated by the catering establishment is used to support the operation of the school does not make the catering establishment incidental to the school." Excuse me. If a building owner need only claim want of revenue to begin an accessory use, the character of residential neighborhoods might devolve into commercial ones, with community facilities opening stores and for-profit activities in residential districts. Second, the temple advertises and directs concert event sales to the greater community. To be incidental to the house of worship, one might expect the events to be geared to its current membership, or at least be in a connection with one of the synagogue's programs. There's no evidence of such here. The rabbi says virtually anything geared to gathering is relevant to a synagogue purpose, but more is needed to demonstrate that a third-party, for-profit contractual arrangement selling tickets for the events is incidental or customary to a house of worship. In the prior mentioned Vishnitz catering case, the board analyzed whether the catering facility at a premises at a yeshiva and synagogue was incidental and concluded that the proposed catering use was not incidental. And I quote, in part, excuse me. Appellant concedes that the catering establishment serves the broader community and that at least 50% of all events are not related to the synagogue or school. And the board notes that the appellant has submitted no evidence that 50% of the catered events relate to the synagogue or the school, even though the appellant committed to doing so. However, even assuming that this is true, it is clear that a substantial amount of the establishment's operation is entirely unrelated to either the school or the synagogue, end quote. Here, the temple does not claim that any of the events are related to the synagogue. It concedes that 100% of the events are not related to the synagogue, but in fact is open to any members of the public who may purchase tickets to these amplified concerts and spoken word events. Applicant has also not shown that it is customary for a house of worship to contract with a third party to provide commercial events. But even if the applicant shows that it is customary, it would still need to show that it's incidental. Third, the TPA process is essential to the department's ability to ensure that the proposed concert and spoken word events remain accessory and that it remains incidental to the house of worship. Commercial concerts could have an impact that, left unrestricted, would negatively affect the neighborhood. The department has already received complaints of crowds from rock concerts at the premises. The TPA process allows the department to approve such use in a manner that protects the integrity of the residential district by providing a check on the intensity and frequency of the use every 90 days to help ensure that the use remains incidental to the synagogue use. To allow this proposed use unfettered would inhibit the department's ability to scrutinize whether such use is accessory and would provide no direction for the house of worship. Just as the board upheld the department's rejection of a proposed accessory catering at the school and synagogue at 1824 53rd Street because of the history of complaints at this site, the department requests that the board uphold the department's rejection of proposed commercial concerts and spoken word events as a de facto accessory use. The appellant has invoked a federal religious land use law, RLUPA, and pointed to events at nearby community facilities, the Brooklyn Library and Brooklyn Museum, to declare that the city must now allow amplified volume concerts at Union Temple as an accessory use, which would mean their certificate of occupancy could reflect such use. The department disputes the appellant's assertion that the temple is being treated less equally than the Brooklyn Library and Brooklyn Museum. The department has allowed concerts, festivals, and carnivals at those premises where 75 or more persons will occupy the space only with TPAs, just as it is requiring at the temple. Moreover, Brooklyn Library and Brooklyn Museum are cultural institutions, not religious institutions, and cultural institutions are more likely to engage in concerts and spoken word events for the community. There is no valid RLUPA argument here. For the reasons above, and because it is necessary to facilitate enforcement, the department respectfully requests that the board affirm the department's December 19, 2019 decision that a public for-profit amplified concert and spoken word events do not qualify as a de facto accessory use to this house of worship, so that the department may permit such use only on a monitored basis through the TPA process. Thank you.
Okay, thank you, Mr. Walker. So I know this was a prepared statement and you couldn't possibly have had time to respond to our comments at the review session. And but I would like you to not necessarily here, and I think it would be better if you do this in writing in particular because we need to move on to other cases. But there are a few things. One is the statement that a TPA will cure all ills when we've been informed, which needs verification because I didn't look that up, that this synagogue, or actually this venue, has received a TPA to hold these events, and that the TPA only expired in December. And so even if there were a complaint, it was a complaint relating to an event that was sanctioned by DOB under a TPA. So if the TPA cures all ills, then why was a zoning violation issued here? That's the first. And the second is, can a TPA cure all ills? With respect to zoning, I think that was a legitimate question posed by the appellant because it's a zoning question. TPAs are for safety, to make sure you have adequate egress and so on for the size of the crowd. There's that, and then you do need to really address much more deeply the varied approaches that DOB takes to different kinds of community facilities located in residence districts. It really needs to be something consistent, and we need to understand much better why you allow it in some places and don't allow it in others, and whether the accessory use analysis has actually been conducted. You know, for instance, if the Brooklyn Museum and the Brooklyn Library, these are public institutions. I'm not sure if the Brooklyn Museum is privately owned or publicly owned. Actually, I think it's privately owned, but still, if it would the same thing be permitted in all of the other community facility buildings throughout the city, or only not permitted when there's a complaint, right? And this is the problem I'm having. I know DOB is complaint driven. Actually, I think one of the reasons that the 583 Park Avenue location, I think that was the location, failed in court was because the court was upset that there was no real parameter being given by DOB so that an institution can know when can we do it, when can't we do it. And because the hotel, the residence hotel, the Beekman, was allowed to hold events where in a residence district where and didn't even get a what do you call it? It wasn't really reprimanded. They may have gotten a violation, but they weren't reprimanded to the same degree as 583 Park. So the disparate approach is what is really problematic here. Mr. Fisher's recommendation for a TPPN is not a bad idea. For the next hearing, I am going to actively invite city planning to send someone to listen to this, because really part of the difficulty is DOB is required to figure everything out without any help. And you know, you're always put in such a difficult position, and you're always forced between the will of the community that complains and the will of the owner who has arguably a right or arguably doesn't have a right, you know, depending on the situation. So I thank you, and I would like you to respond to those questions and listen to our review session, also the video, and go through the questions very systematically. And the same instruction to council and members of the team for the appellant. So I would like to see if there is any members of the public who would like to speak on this, and then we're so behind.
So the item is 2019-176A, 17 Easton Parkway, Brooklyn.
So if you would like to speak on this application and you're in the Zoom room, where we have 14 people waiting in the Zoom room, thank you for your patience. If you'd like to speak, raise your Zoom hand. And if you're dialing in by phone, then please dial *9 to raise your Zoom hand. This, in terms of submissions, this needs to be done with a briefing schedule. So what I would ask the two parties to do is communicate with each other about a briefing schedule and then send it to Ms. Matias, and then we can schedule the hearing that way, okay? But we really do need concrete answers to our questions and not sort of touchy-feely. It feels as if this is something that's commonly practiced elsewhere, and more that really solid facts, okay? So with that, I'd like to move on to the next one. Last parting shots from anyone, only if relevant. I really don't want to continue this anymore. I think we've heard, okay? Commissioners, everybody okay? Moving on? Yes, okay, thank you all for calling in. We didn't have anyone raise their hand in the Zoom. Okay.
Okay, next item is zoning calendar, continued hearings, 2017-34BZ, 311 Adams Avenue, Staten Island. Should be Todd Dale.
Is it? It's Todd?
I believe so. It's jealous. Whose case is jealous? I don't know. It's Todd.
You want me to contact him?
Yes.
Okay.
I think it might be Adam Rock. Let's see who spoke last time.
It's Adam, wasn't it, maybe?
I think it was Adam, yeah.
No,
no,
Todd
because-
spoke. It was Todd. Sorry.
It's Adams Avenue. That's why when I see the word Adam. There he is. Okay.
Good morning.
Good morning. It's really
Good
afternoon.
afternoon.
I was trying to get in and it wouldn't let me in the first time. So,
Okay.
Well, we're moving into the afternoon pretty soon anyway, so let's see what happens.
all right.
All right, let's swear you in. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
I do affirm.
Please go
so-
forward.
Good afternoon. Did listen to the review session and heard the comments from the board about how there were some tightening up of materials. I would just quickly respond to some of those items, maybe seek a little clarification on some points, and get ourselves set for another submission. First, with respect to the title, we will provide an updated single and separate chart. As you noted, Chair, there really hasn't been any change in ownership, but we'll update it since it's been some time since the original was submitted. With respect to the curb cut, I know there were a few different concerns. The most recent plans did revise to change the curb cut because there was discussion last time about how it wasn't centered. So the new design did seek to provide a 17-foot curb cut that was centered on the accessory parking spaces that moved. A few points. First, with respect to some comments from DOT that Ms. Prenga forwarded to us this morning. The architect wasn't able to jump on the hearing because of another commitment, but we've been trying to email back and forth. He confirmed for me that the utility pole is actually 7 feet from where the curb cut is shown now, and we can note that on the plans. So that should address the DOT comment regarding distance. There is a guide wire that would need to be relocated, but the property owner would agree to moving that in conjunction with getting an approved builder's pavement plan.
So the guy wire was described as being expensive to move. I don't know anything about that. So be forewarned, right? If you pick that.
Yes, definitely forewarned. As was communicated to me, it would be definitely expensive to move the utility pole, but the guy wire, they said, is something that they've done and they do not think would be prohibitive. But we'll definitely address it, and we'll note the distance on the plan when we resubmit revised plans. Now, regarding the curb cut, it was an interesting discussion with respect to 25632 and the fact of how does DOB apply street frontage as to whether it could be a 10-foot maximum, or if it's more than 33-foot street frontage, it could be 17 to 18 feet. Per discussion, per the recent communication I had, we'll clarify in a submission, but the architect says when they've dealt with these corner lots previously, that DOB has allowed the 17-foot curb cut. That noted, I believe, Chair, you also noted that the current objection of record does have 25632 listed on the objection. So, we're flexible with respect to the curb cut. We understand it can't be near the curb. We think that the current design, where it matches up, is a better and safer design because it's not going to infringe with the corner. It doesn't infringe with the utility pole. The preference is to keep the 17 feet because it matches up. But we can be flexible as far as examining designs. But I think the big picture is that it is on the DOB objection sheet for this case. So if DOB were to raise an issue, it could be addressed in a resolution or the variance if it's granted. But that said, the development team said that they didn't think DOB would raise that issue. So, I don't know how we want to address that.
So I'd recommend so that you don't have to come back, it would be a mess, that you re-ask for the waivers on the curb cut, just in case. And then if they don't object, they don't object. You have the waivers.
What I was going to say, sorry to interrupt, but I was going to say the current objection is currently on. It does say 25632. So.
No, I know, but your statement of facts, and that's what our council uses to draft a resolution. The statement of facts says we don't need a curb cut waiver anymore. So you need to amend that so that it's clear in our papers that that's what you're asking for. Okay.
Understood. We'll get clarification on that and come back. But if DOB, sorry, go ahead.
One more thing. I wouldn't, I'm not saying that necessarily you have to change it, but I'm curious about whether if you had a 10-foot wide curb cut centered on the curb, whether that would give you a little bit of opportunity to have some green on that frontage. So you come on and then it sort of splays to the garage. There may not be any room. It may give you something that's so negligible, it's not worth it. But if the architect could just look at it and then include with the submission a little sketch that shows how that would work, then maybe that's a way for us to close that that door sort of.
Okay, so what we'll do is we will reach out to get clarification on whether the 25-632 objection is needed. And then we can also provide just a brief schematic as to if the curb cut were reduced in width, if there was any possible landscaping or greenery that could be added of substance.
Mhm, right.
All right, good. With respect, there was discussion of the survey. Just to clarify, the architect said that the current plans are based on the NAVD 88. They can add a note about that, but the survey that was submitted with the most recent submission, it is a little confusing on the survey, but the survey did list the borough datum in type, but there's actually a handwritten note that says in 2016 it was updated to include the NAVD 88. So that was what was used by the architect.
So no, but so that's actually, I think the architect used the wrong datum. So the survey shows two different elevation points. One is in like parentheses and one is in brackets.
Right.
One in parentheses is the one that's in Brooklyn datum or something. And the one that's in brackets, I believe, is the update that's in NAVD 88. If you look at, so one says 9 feet, that's the one in parentheses.
Mhm.
And the other one says 11 feet, that's the one in brackets.
Right.
I believe the one in brackets is NAVD 88. And when you look at the drawings, the architectural drawings, they're using 9 feet as the curb elevation or the grade level elevation. I think they're actually using the old one, the wrong one.
Okay.
Now, maybe I'm reading, but that's why I was saying the surveyor really needs to check, because otherwise, or you need to clarify which one of those two numbers on the survey is NAVD 88, because I have to say the surveyor did not make that clear. It simply said that they provided the number, but not clear which number is the correct NAVD 88, so that the architect can be sure they put the right one on their drawings.
Understood. We'll get clarification and submission, and we'll make it very clear on the plans as far as what's used. But we understand the issue. Okay.
Okay.
We'll add the dimensions to the balcony. They did correct. There was issues with balconies last time, and some balconies were removed, but we will show the dimensions for the proposed balcony, the one that's remaining. In respect to the materials, there was a change where they removed the proposed vinyl siding per discussion at the previous hearing. And I know you brought up comments about the handy plank. I'm not going to pretend that I'm a material expert, but I'm curious if the board has a list of materials that they find acceptable or something, just so we can propose something that works out, because I think the developer is agreeable, but absent a list, or I don't know if there's a way we can check and run materials by to see which ones are going to be okay and which ones aren't.
No, it's actually quite simple. Anything that's described as an exterior insulation finish material, not okay, right? And nobody ever showed us vinyl siding before this applicant. So that's where vinyl siding was not okay. However, hardy plank is a cementitious material that works really well. That's what's shown on 3 sides of the building.
Okay, so 3 sides show hardy plank and the other one doesn't, so we should just be consistent with the hardy plank.
So the one on the front, which they kind of want to make it look like stone or something like that, they're showing that one as what's commonly known as EFIS. That is the one that needs to change. And for their information, I'm sure the architect knows this, hardy plank, or that's a brand name, but hardy plank and its equivalents also come in all different kinds of finishes. So you can accomplish the same thing using the cementitious material instead of using that nasty foam stuff.
Got it. So the short answer is change the one on the front to match up to a suitable material along what you're describing. I've got the video, the video of this that I can also reference, but I think that should be an easy change. So we'll get that fixed. Okay, good. So we went over balcony material, curb cut, title, the survey. With respect to the height, I know that Commissioner Otley Brown brought this up. I'll get clarification from the architect. And I believe it has something to do with the pitch angle, but the vast majority of the building height is 29.7. And when I just did a review while I was waiting, sheet BSA 14 listed as 30 feet 3 inches. There's a tiny little peak that, due to a pitch, one small portion of the roof that extends above 29 feet 7 inches. I'll get some clarification as the architect, but that's where that 6 inch, or excuse me, that 8 inch difference is, that little peak. And I think it may have something to do with the pitch of the roof, but I'll ask for clarification with the architect as to why that's included and why we have that tiny little bit that's different.
Right, but if it's the highest point, shouldn't that be what's noted in the documents?
I agree, yes. So we'll get the clarification, and if that is going to remain, then we can change building heights everywhere. That said, I still believe, sorry, go ahead.
Mr. Gale, I would not do that, because the problem is this, arguably, this building, because it doesn't comply with section 64-131, can't measure off of design flood elevation. So it needs to measure off of grade. The architect went out of their way, it seems, to make sure that when you measure off grade, it complies. So it complies both with street wall height and final height at 29'7", plus you add the distance to grade, right? So 29'7" is the maximum it can be. If it wants little doodads, then the doodads have to be permitted obstructions, in which case you wouldn't measure to that, you wouldn't count the permitted obstructions, right? Like a dormer or something, if that's allowed to exceed the height. So be careful, don't mess with that. They went through a lot of trouble to make sure that both numbers worked each time, it seems to me. Okay. But
so the short answer is we understand what the issue is. We'll get some clarification with a submission of plans as to those two figures and an explanation as to why they're included.
Okay, good. And then the last, the builder's pavement plan is supposed to be showing existing conditions, or no, sorry, not the builder, the survey is supposed to be showing existing conditions, which is showing a sidewalk, but there isn't any sidewalk.
That is correct. Now, we'll get some clarification on the survey. The firm that was the engineering and architecture firm for this that is now involved with the project didn't actually do that survey, but they do their own surveys. So I will ask them to review the survey with respect. You're talking about that, I know the sidewalk, it says it's an existing sidewalk along Adams, and it stops probably 15 feet from the corner. So we'll review that survey. Oh, and then one other thing with respect to the curb cut, which I forgot to speak to, just to confirm, there is no existing curb cut on the adjacent home, but we will note that on the plans to show that it would comply with the 13-foot required distance.
Good. Okay, excellent.
I think that's the list. You know, and we've got the marching orders on getting that clarification. I think we should be able to address those promptly.
And the architect should listen to the review session, because Commissioner Shetta gave some handy advice about structure.
Yep, turn framing for the first floor to mitigate the load. I have notes, but I will also, as regular practice, copy and paste the video link for our design professionals.
So obviously we don't control the structure, but if it saves money, et cetera, and it's a better design, they should look at it.
Understood.
So,
thank you, and we'll pass it on.
Okay, so I would like to then go to the public.
This application is 2017-34BZ, 311 Adams Avenue, Staten Island. If you're calling in at 646-558-8656. ID number is 970-4086-1874. And you can Zoom *9 if you're on the Zoom.
If you call in and you want to raise your Zoom hand with a phone number, you dial *9. So We have 14 attendees in the waiting room. If you would like to speak on this application, please raise your Zoom hand, and there's one phone number. Dial *9 if you would like to raise your hand on this one. In the meantime, I'm not sure that there are, so all we're really doing is clarifying things we already know. So I'm not sure that we need to keep this open anymore. So unless our council has an objection, are we okay to close this?
No objection.
Okay, and commissioners, everybody's okay with our closing it? Yes, I see everyone nodding their heads positively. Okay. Or affirmatively, I'm avoiding the word positive from now on in my vocabulary. So, so is anything you wanted to add, Mr. Dale?
No, thank you for your review, and we'll get those changes made. We can be very flexible with submission date, but I would say considering the holidays, probably a few weeks to get things submitted, but we can be flexible.
So let's say mid-January submission?
That sounds lovely.
Okay. All right. So I'd like to make a motion to close then.
Chair Promoter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
Aye.
Okay,
Okay, thank you. Happy and healthy holidays to everybody.
thank you.
Thank
Next
you.
item is item number, sorry.
Wait.
Break.
So as we can guess, this one is pretty long, potentially. And we have 15 minutes before the 2 o'clock session. So one option is the next one a shorter one? Sorry. let me just-
Beaumont?
Yeah, Beaumont is a short one, which we could handle now, right? Yeah, right. Why don't we jump, with apologies to the applicant that's just up now. We'll jump to Beaumont, and then we'll leave this hearing, the morning hearing, and go to the afternoon hearing where we'll pick up what's left of the morning, right?
Okay. So the next item is, we're switching this up. So the next item is 31, 2019, 35BZ, 235 Beaumont Street, Brooklyn. The applicant is also Mr. Platnick.
Hi, Elise Fullader from Eric Polanic PC. I'm supposed to have the architect on the phone, but I didn't know we would be up next. So I'm just gonna try to give him a call again. I was keeping him on standby.
I don't know that we need the
him.
architect.
Okay.
Sorry.
I thought you wanted him to explain the NADV 88 situation.
So it's
Hello.
not.
Oh, he's here.
Sorry.
Yes, I'm here.
Oh, he's there.
Aha.
Oh, okay. Great.
Hello.
Let me swear you both in. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions?
I do.
Go.
I do.
So I have here Mr. Alex Otovsky to explain the NADV 88 question.
Okay,
Hi.
go ahead.
Yes, so the building is designed for NIVD 88. What was your exact question? What was it?
So, so the 2013 set of DOB approved plans.
No, that was designed for Brooklyn Datum. This
Right.
is designed, the new plans are for NIVD 88.
Okay, so that was the issue because the first floor is, when I'm reading my own notes, the first floor is shown on the new plans as higher than DOB. So DOB used Brooklyn datum and now you're using NAVD 88.
Yes.
Hence the difference. That's
Yes.
all I wanted. Okay, let's see.
And then he can also answer the question if you need about the joists. There's going to be new joists on top of the old ones, but he can explain that too.
Yeah.
No, it's actually, that's not the question.
Oh.
I think it has to do with the graphic on your section. And it may just have to do with what we get when it gets converted to a PDF. The graphic on the section that we see shows the second floor as a new construction. both the floor and the roof of the second floor in terms of the graphic. So if you could just simply, whatever it is, when you convert it to a PDF, resubmit it to us, but convert it as a PDF and check that the line weight and everything is reading very clearly as existing construction, because it's not physically possible to do what's shown on the drawing. The building exists, right?
Mhm.
But the drawing is showing it potentially as being new construction, which doesn't make sense. That's really all. It's really a graphic correction.
Okay. And that you're referring to a page, the very last page, right? The section, the large section on the last page, or the long section?
Yeah,
Section
so
one,
it's
or section 2.
Section 1-1 is the one that shows all new joists and flooring on the second floor and second floor roof, onto which you add the third floor. I know that you're just adding on top of an existing roof.
Okay, no problem. The graph.
And those are the only questions. All right.
Okay,
So I appreciate that. So we just really need a resubmission. Check your PDF very carefully before you send it to make sure all the line weights and shading and all that stuff is legible. Okay.
Perfect. Yeah,
Great.
I will.
Okay, so then I would like to go to the public.
So this case is 2019-35BZ, 235 Beaumont Street, Brooklyn. If you're calling about that case, 646-558-8656. ID number is 970-4086-1874. And if you're in Zoom, *9 to speak.
Okay, so just give it a second to see if anyone's calling in. Right, so there's 2 people who dialed in. If you want to speak on this application, *9 is what you dial and it raises a hand. Otherwise, if you're in here through Zoom, please raise your Zoom hand to speak. Okay, so so far, no Zoom hand. Oh, there is a Zoom hand. Okay. Yes,
Please
so
press *6 to unmute.
so the person who raised their hand to speak with last 3 digits 942, dial *6 to unmute yourself. *6 to unmute yourself. Because we cannot unmute you. There you go. Please state your name.
Mark Meyer Appel. I'm the founder of the Bridge Multicultural and Advocacy Project.
This is, are you here for 2721 Nostrand? Because this isn't it.
Yes, I am.
Sorry.
Yeah, so we're talking, it's a different case. So just, we're going to move you back into the waiting room, and we'll allow you to speak later, okay? And we're going to have to give instructions to everyone because we're going to move into the 2 p.m. session slightly later. Okay, so I would like to then close this application because everything was submitted. I appreciate your cooperation with the board's comments and directions. So the only thing we're going to need submitted is that clean set with the clean PDF, and otherwise all the other comments are okay.
Perfect. Thank you so much.
Thank you,
Okay,
Alex, for coming.
Yes, thanks. So then a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Okay,
Do we
so
have
now what are we doing?
another- wait, Tony, do we have another short one or no, that's it, right? It's the only
Madam
short.
Chair,
You
Madam
you
Chair.
have the Bone Street, they submitted a revised plan?
Yes, I just want to alert the board that as requested this morning, the submission on that FAA application, I believe it's Brown Street, was just received.
Where I don't see it though.
I just forwarded 2 sets of plans, one bubbled, one clean.
I also forwarded to you too as well, Margaret.
What
Just came
time?
up. I can see it.
It's Mark Red.
1:44 p.m.
Yeah. I'm sorry. I didn't scroll to the right place. Okay, let's just take a quick look and close 10 minutes. In the meantime, I would like to announce to the people who are listening that we're going to be moving in 10 minutes to the afternoon session, which means you need to disconnect from the Zoom call and then move to the afternoon session, which is a different dial-in number, which we'll give you in a minute, okay? So I just want to make sure that we've got the revised plans. Did we check them? Because that's the thing that's a little tricky. I'm wondering whether we could maybe do that in the afternoon, like give us 10 minutes to check it, because I can't really do this now in front of everyone, right? So why don't we do that? Let's close this morning hearing after we've given everyone instructions, and then it'll give us time to review these drawings that were just submitted that need to make sure that all the references to NAVD 88 and AMSL are the same now. Yeah. So, okay. So the afternoon session dial-in information.
You want me to do? Oh, okay.
For everyone. Okay, everyone listening, there's you need to go. How do you get to the Zoom room link? You need to go to what is the Zoom room link information?
Council.
Council.
I'm Sharon.
Okay. Oh, that's great. Okay, so this is the Zoom ID number after you go to Zoom, which will begin at 2 p.m. sharp, is 943-7193-9463. That will get you into the 2 p.m. public session. And if you're calling in, it's the same ID number. So you're going to be dialing 646-558-8658.
Madam
Sorry.
Chair, can you repeat that? I apologize. We have a bunch of people. We're all on the phones. Nobody understands what's happening right now. There's about 30 people.
Okay, so let's do this again. So unfortunately,
Sorry, Chair, can we also confirm the webinar ID? Because I'm looking at a different number.
I have a different number. Yeah, I was just going to say that. I have a different number.
We're all very confused.
What?
There's a, Kurt, I have 928-1347-4075 for the afternoon. Not the number you showed.
That doesn't sound right.
Well, that's what I have on the right here on the agenda. I mean, I don't.
Everybody on our team thought it was this number. We could stay on
everyone,
this. Okay.
Please hold just a second. Yes,
Stop
that was
talking,
the
yeah.
wrong number.
Sorry.
Okay, so we're going to display. So I just want to explain as we're setting up what the correct number is. The way that Zoom works, we have a morning session and an afternoon session. The morning session has a different Zoom access number than the afternoon session. Because we're running late on the morning session, we're going to lose our morning Zoom hearing access. So we need to switch to our afternoon Zoom hearing access. And so you will need to get off of this Zoom call in a few minutes, and then come back to a new Zoom call by going onto Zoom. And then, is this the correct number, Tony? That's the one you have?
That's what I have.
Then entering the Zoom webinar ID number 928-1347-4075. And if you called in, you'll call in again, the same number you called in before, 646-558-8656. And at prompt, you'll put in that same number, 1347-4075. All this information is on the YouTube, the YouTube hearing. You'll be able to see it displayed on YouTube. So you don't necessarily need to memorize what I just said. It's displayed on YouTube for the afternoon session, and we'll give people time to dial in for that next session. Okay.
So the first case that we're going to discuss is 2019-24 BZ 2721 Nostrand Avenue. We're bringing it over to the afternoon session.
Yes,
May I
and
ask
but
a
we're
procedural question? I don't
Yeah.
mean to interrupt. There was this morning when we all tried to log in, there was a code after that we all needed to enter, that we all encountered, a lot of people. Is there any sort of other code, a passcode of any sort that anybody may be aware of that needs to be entered just in case? Because we all hit that this morning. I think it was on your calendar. Austin advised me it was on your calendar as a passcode.
Yeah, I do see a passcode in the email I'm looking at, which is 253535. I will add that to the PowerPoint now.
Let me just repeat it back. 253535.
Yes.
Okay, if you can bear with us, maybe you want to give us a little time because it's
Sure.
it's very complicated it's very hard for people. So, and
Yeah,
we working.
yeah.
We have good stuff here, but we'll get in. Thank you very much.
All right, please. Okay. So we're going to give a few minutes. We'll give about 5 or 10 minutes. In the meantime, we're going to also discuss a case that we couldn't decide on yesterday. We'll discuss that. So it'll take a few minutes in the afternoon. And by the way, I also want to give the commissioners a lunch break. So it's 2 p.m. Normally we take a 30-minute lunch break. So maybe that's the best way to allow all the people to join on with time. Okay.
So 2:30?
Yeah, so actually we'll convene at 2:30. That'll give everybody enough time to figure out how to get onto Zoom properly and
Thank you.
to ask questions that they can't figure out how to use it. Okay.
Thank you.
All right.
We
then.
needed that. Thank you.
All right, this concludes the morning session. We'll resume at 2:30.